Good afternoon. The Senate Judiciary Committee will come to order. We are going to continue our agenda, but I'm going to tell folks, those of you who've been around a while understand this, we will not necessarily be taking the agenda in the order in which it appears on the printed page. Depends on the availability of chief authors and testifiers. So, members, we're going to start by going out of order. We're going to take Senate File 1352, the Minnesota Rehabilitation and Reinvestment Act.
Mr. Chairman?
Senator Pappas.
Is there a new agenda coming?
Can I hand it out?
Here.
Okay. Yes, it's coming. Claire, it's my bill. Yes, sir.
Do you have an agenda with where things are going and all?
Nicole has. Yeah.
All right.
Do you have an agenda with where things are going?
I need another minute. I was busy getting all of the other things we need to put the bills places.
You told me to go ahead and start.
I know, that's why I figured you could talk about it for a minute or two.
I will.
So then I'll have that.
From over there.
Okay.
Here we go again.
There it is. Senator Latz.
Madam Chair and members, Senate File 1352 is the Minnesota Rehabilitation and Reinvestment Act. This is the first committee stop for the bill. I have an A1 author's amendment that I move adoption of.
Senator Latz moves the A1 amendment. It is an author's amendment. All those in favor say aye.
Aye.
Okay, the amendment's adopted.
The A1 is a delete everything amendment, so members please use that to work off as we're considering the bill. The Minnesota Rehabilitation and Reinvestment Act, or the MRRA, is intended to assist the Department of Corrections in doing what's in its name. Correct. It has four main components. It's what I would characterize, or what the department has characterized as a smart on crime sentencing reforms based on how people use their time in prison, not just how much time they wait there. It's an incentive-based program, which anyone who has raised kids will understand tend to work more powerfully than punishment in changing behavior. The four components are an individualized rehabilitation plan, an earned release system by which inmates can reduce the amount of time they spend in prison by affirmatively completing the programming which would be part of their individualized rehabilitation plan, an earned supervision abatement, which is comparable to the earned release, but after they are out in the community under Department of Corrections supervision, and a justice reinvestment fund, which will utilize some of the resources that are saved in terms of a prison bed space and funding to beef up other crime prevention, supervision, and victim support services. Members, we had an extensive presentation about this bill in committee not too long ago. So I have with me Commissioner Schnell. The intention for this is, actually I should confirm with staff, be rolling this over or laying this over. The intention is to lay this over for consideration, for inclusion rather, in the budget bill. So I guess I will ask Commissioner Schnell to make some remarks and then we'll leave it open for conversation. Thank you.
Thank you. Commissioner Schnell, if you could begin by stating your full name and title for the record.
Yes, Madam Chair, thank you. Paul Schnell, Commissioner of the Department of Corrections, and we thank you for the opportunity to just speak on this a bit. We were here, as Senator Latz mentioned, in the latter part of February, talking about this bill. You heard at that time from Dr. Grant Dewey, who is the Department of Corrections researcher, who talked about the fact that we know that incentives work. We see this in our own research of what happens in our challenge incarceration programs, our boot camp programs. We also know that in 2018, then President Trump signed into law bipartisan legislation, the First Step Act, which provided earned time credits for completion of recidivism lowering programs. As mentioned, this is 4 components, really well developed, driven by research and evidence. We would ultimately provide the opportunity for earned incentive release, moving that person out as early as 50% versus today 2/3. The savings from they would then go on to supervised release. They would be able to earn abatement status. Abatement status means for every 2 months they do well, 1 month goes into abatement status. It still hangs over them, so to speak, but they would be on a unsupervised status during that time. And then ultimately the savings, as Senator Latz mentioned, goes into a pot. These are the direct cash savings from the earned incentive release. And those dollars get distributed in 25% allotments, one to support victim services, second to provide supports in the community for community supervision, third to do primary prevention. We want to invest upstream. And fourth, 25% gets returned to the state treasury as a dividend to taxpayers for investing in this type of initiative. And with that, Madam Chair, I would stand for any questions you or the committee may have.
Senator Pappas.
Thank you, Madam Chair, and thank you, Commissioner. I'm just wondering how this new program would work with, would interact with work release.
Commissioner Schnell.
Madam Chair, Senator Pappas, work release is a program that would absolutely be connected to this. There's a variety of ways that we would be looking to use work release. It could be as part of this, moving somebody out, for instance, into treatment using work release, which is today permitted by statute. It could be for educational release. In addition, we know that there may be people who serve longer sentences where work release becomes a very important transition tool for people who've been in a long time. And that's, so we would build in and integrate work release and other types of release programs into MRRA.
Great, thank you.
Are there questions, comments, committee members? All right, final words, Senator Latz.
I ask that the committee chair lay this over for possible inclusion, except Mr. Backus may have something. He's waved. No, he doesn't.
There's been a change of plans, Senator
Oh,
Latz.
okay.
So I'll make the motion for you that you move to that Senate File 1352 as amended be recommended to pass and re-refer to the Committee on State and Local Government and Veterans.
I'm just along for the ride. I'll make the motion.
Yes, thank you, Senator Latz.
Madam Chair, roll
Senator
call.
Kroon.
Roll call.
Roll call has been requested. Roll call granted. The clerk will take the roll.
Chair Oumou Verbeten,
Yes.
Senator Latz,
Yes.
Senator Limmer,
No.
Senator Carlson,
Yes.
Senator Eichhorn,
Yes. Or, excuse me, no.
Senator Icorn is a no, is that correct?
That is correct, Madam Chair.
Senator Howe? Senator Kroon?
No.
Senator Pappas?
Yes.
Senator Seeberger? Senator Westland?
Yes.
Senator Howe? Senator Seeberger?
5-3.
Okay, there being 5 yeses, 3 nos, the motion passes. And this will be sent to state, local government, and veterans.
Madam Chair.
Senator
Madam Chair,
Pappas?
Sorry, I should have asked this question before, but could someone tell me why it's going to state and local? I mean, I think they're about ready to adjourn, and today is the deadline.
Yes, it was on the advice of council. I'll ask Mr. Backus to explain.
Madam Chair and members, the bill has the commissioner adopting, I forget what they call it, guidelines or policies for implementing the bill in terms of how the release program would work. And state government has, at least our state government council had that on the list of bills they would need to see. I believe just the process would be here is, we've done this in the past, we've dual-track bills, so I think if they do hear it and they make any changes, we would then, assuming it goes into maybe the omnibus bill, we could pick up those changes after they've made it.
I see. So
Senator Pappas?
Sorry, Madam Chair, Senator Latz. So the plan is to put this in the omnibus bill, but also to dual track it and send it to State Gov. And they could hear it after deadline because it doesn't matter. Okay,
Mr.
great.
Backus?
Madam Chair, members, yeah, that's correct. I mean, we don't need the file anymore to, if Senator Latz chooses to put it in his omnibus bill, and they don't even technically need to pass it out of committee, as long as if they do amend it, then we'll just pick up those amendments.
Great, thank you.
It's going to be a moment when we decide which bill to take up next.
became a rival, so would you like to take up 1325?
Sure.
Okay. Pass them out.
All right. Senator Latz, we will be taking up Senate File 1325.
Thank you. Perfect.
That's just stats. In case you need
I would have made something up, which is what I usually do.
You go for it. I can cover this if you don't.
I'll use it. That's great. Thanks for doing it.
All right, Senator Latz, when you're ready.
Thank you, Madam Chair and members. Before I go into the content of the bill, I'm going to ask that the committee adopt the A2 amendment as an author's amendment.
Senator Latz moves the A2 amendment. It is an author's amendment. All those in favor say aye. Aye. Any opposed? Okay, the amendment's adopted.
So, Madam Chair and members, in 2012, the United States Supreme Court issued a decision called Miller versus Alabama, in which they banned sentences of mandatory life in prison without release for children under the age of 18. The court held that because of their diminished culpability and greater prospects for reform, juveniles are less deserving of the most severe punishments. Minnesota was one of 28 states whose sentencing laws thus became unconstitutional for juveniles after Miller. And it is just one of 4 states that has not yet fixed its own laws. Senate File 1325 abolishes the sentence of life without the possibility of release for children in Minnesota, making Minnesota the 28th state to do so and aligning Minnesota with states as diverse as West Virginia, North Dakota, Nevada, and Maryland. Note that the political diversity as well as other diversity of those states, some of which are decidedly conservative-leaning and some which are not. This file provides a review opportunity, I emphasize opportunity, for those who have served at least 15 years in prison to see who they have become during their years inside the prison. It does not guarantee release, it just guarantees them the opportunity to appear in front of a court, for the court to analyze and determine whether or not release is appropriate at that time.
Release board, actually.
Actually, thank you. My testifier is already making sure I'm factually accurate here. It's in front of a release board. An earlier version of this bill a number of years ago was in
Yes.
front of the court.
Yes.
This is a different mechanism.
Yep.
So they would go in front of a release board, which is established in this bill. It creates a mechanism for review through what will be called the Indeterminate Sentence Review Board. The bill has the support of a number of critical stakeholders, including the Minnesota Attorney General, the Hennepin Ramsey County attorneys whose jurisdictions have close to 80% of those who will become eligible for review, Violence Free Minnesota, and more than a dozen other advocacy organizations. You will see in your packets that the bill also has the support of survivors and family members of victims of youth violence. I'd like to close with a passage from their statement before turning to our testifiers. Because of our painful experiences, we are deeply committed to the hope of redemption and second chances, and a belief that all of us are more than the worst thing we have ever done. We believe that when a person who has served a lengthy sentence for a crime she or he committed as a child is able to demonstrate rehabilitation, we must give them an opportunity to lean into the future awaiting them outside prison walls. Madam Chair, I ask you to hear from our testifier.
Thank you, Senator Latz. Professor Perry Moriarty, or should we go to our virtual testifier? Okay. Preston Shipp, you can unmute and state your full name and title for the record as you begin.
Thank you, Madam Chair. My name is Preston Shipp. I serve as Senior Policy Counsel for the Campaign for the Fair Sentencing of Youth. And I appreciate the opportunity to be with you virtually. I'm sorry I was not able to come be there in person. I was in St. Paul last week over on the House side, and I'm sorry I can't be with you all today. But before I started working for the Campaign for the Fair Sentencing of Youth, I was a prosecutor here in Tennessee. And, you know, when we were working on cases, whether that person involved in the case was 15 or 16 or 17 years old, what we focused on was what that person had done, the harm they had caused, what they'd been involved with. That was where we put all of our focus and energy. We did not have the opportunity as prosecutors to think about what that 15-year-old or 16-year-old or 17-year-old would be, who they would be 15 years down the road when they were a 30 or 31 or 32-year-old adult. And 27 states have concluded that that is a question worth asking. That when you're talking about someone who's that young, who the law recognizes is constitutionally different from adults, the adolescent brain science confirms is fundamentally different from an adult, we don't know who that person is going to become. And we have 950 plus people who are now home who were told as kids that there was no hope for them but for them to die in prison. And those folks are serving their communities. We have folks who are running violence intervention programs, social workers, school teachers. We have a person in Michigan who runs a food pantry that feeds 700 needy families per week. We have pastors, and you name it. You know, we have folks who were told as kids that they were the worst of the worst, who with the passage of time invested in rehabilitation, and when they were given that second look, they were able to demonstrate that they have become some of the best of the best. So again, thank you so much, Madam Chair and Senator Latz for introducing this legislation, because when you can get Arkansas and Massachusetts on the same page, and when you can get West Virginia, which is what this bill is modeled after, West Virginia did this in 2014, said that anytime a kid is given a sentence longer than 15 years, the parole board is going to take a look at them at 15 years. In 9 years, they have a 0 recidivism rate. So states are getting this right, you know, whether you're in the Dakotas, California, or Nevada, Utah, Wyoming, all the way over to Maryland and Virginia. And so really excited for Minnesota to have this opportunity. If you have questions about what other states are doing, about the low recidivism rate, the 1.14 rate of recidivism, about the Incarcerated Children's Advocacy Network, which provides all kinds of support once bills like this get passed to make sure that the folks who come home have what they need to succeed, then I would be happy to take questions. But I really appreciate the opportunity to be before you. Thank you, Madam Chair.
Thank you for your testimony. Professor Moriarty, if you state your full name and title as you begin your testimony.
Okay, thank you. Good afternoon. My name is Perry Moriarty, and I am a law professor at the University of Minnesota. I write and research in the areas of juvenile sentencing, and my students and I, over the past 10 years, have represented a number of people who are impacted by the laws that we are discussing today. So thank you very much for giving me the opportunity to testify in support of this bill. I first sat before this committee in support of a version of this bill almost a decade ago. Our laws, our sentencing laws, as they apply to juveniles, people under 18, children, who have been convicted of serious crimes, have been unconstitutional now for 11 years. Our Heinous Crimes Act currently requires courts to sentence youth convicted of certain forms of homicide to life without release. And it has been unconstitutional since 2012, when the U.S. Supreme Court decided Miller versus Alabama. As Senator Latz indicated, Minnesota was one of 28 states that was required to amend its laws after Miller, and 24 of those 28 states have done something. Our state still hasn't, and that is why there is urgency to do something now. As we sit here today, there is no legislative authority in place governing the sentences of juveniles convicted of certain forms of aggravated homicide in Minnesota. Indeed, even as states across the country abolish life without parole, now 27 states have, many more states have no one serving, Minnesota still has that prospect on its books. We have become an outlier in this way. Senate File 1325 will remedy this. I want to emphasize a couple of things about this bill. First, we are providing review after 15 years, and I can't emphasize enough that review does not mean release. There are representatives from the Department of Corrections in the room today who currently are tasked with the decision of reviewing cases and determinant sentencing cases, and they can tell you that review does not mean release. It is not automatic anything except review. This bill, as Mr. Shipp indicated, is modeled after West Virginia. It has been about as successful as any bill in this arena has been. The recidivism rate is 0. And some people have gotten out after 15 years, others haven't. They trust a board of professionals to make the right decisions. There are 97 people in Minnesota currently serving sentences of more than 15 years for juvenile offenses. I want to say a few words about them because they are the people who may become eligible, will become eligible for release when this bill passes. 40 of them have already served 15 years and will become immediately eligible. But here are some important statistics about them. Of the 97 people, 81% are BIPOC. They are people of color. And many of them were sentenced at a time when Minnesota was 90 to 95% white. 80% of these people, or close to 80% of these people, are from 2 counties. And so the prospect of a release board centered in the Twin Cities area with professionals guided by the Department of Corrections who will make release decisions makes sense, given this population. We know that the majority of these adolescents, or people who were adolescents at the time of their offenses, experienced highly elevated levels of poverty, a dearth of services. Many faced familial incarceration. Many have diagnosed learning differences, educational interruptions, and mental health challenges. We know these things. We also know that many of these people committed serious offenses as adolescents. That's true too. And nothing about this bill seeks to undermine the notion that what they did was serious. One of the key features of the review process is that it invites input from victims' family members, from survivors' family members. It invites input from prosecutors. It invites input from the communities that were impacted by these offenses. We believe that's incredibly important. So nothing in my testimony today, nothing in this bill is intended to minimize what happened in these cases. And I can't emphasize that enough. But what we believe and what we are learning across the country now is that people change, particularly when the acts they committed occurred when they were children. And we believe that they deserve to be looked at when they still have time for a meaningful life on the outside to see who they've become. Thank you.
Thank you, Professor Moriarty. We'll move to questions, comments from committee members. Okay, seeing none, Senator Latz.
Members, Mr. Shipp mentioned this, and I'll emphasize it. Physiologically, the brain simply does not fully develop until age 25, or depending on who you listen to, age 28. I mean, that's just the science. Teenagers are notoriously short on the ability to consider consequences of their behavior. Anyone who's raised a teenager knows that. And short on their ability to interrupt the impulses to do things that are not appropriate conduct. They don't have the physical, the neurological capacity to do that as well as an adult does, because the brain just hasn't developed those capacities yet. Not to mention the fact that they're often undergoing puberty and have hormones that are raging and so on. So to hold someone accountable by throwing them into a prison and leaving them for the rest of their lives might be another 60 or 70 years because of something that they had less control over than a biological adult has, is a complete waste of the potential of the kind of lives that they could have. So this bill gives an opportunity for them to show and for others to show who they have become, what they are at the time of review, not at the time the offense was committed, and what they can become in society. That's all we're asking for. It's a chance to make the case before a well-balanced review board. So with that, I guess I will ask, where does this bill go?
Got an answer for you, Senator Latz. State, local gov, and veterans.
They're going to be busy.
So,
And I move that.
sorry, Senator Pappas.
Oh, I'm sorry.
Thank you, Madam Chair, and I apologize if I missed this. So this is called the Supervised Release Board, and the end is called the Indeterminate Sentencing Board. And I'm just wondering how this interacts with my bill, which creates the Indeterminate Sentencing Board, which is very similar to this, except this one requires members to have expertise in neurological development of juveniles.
Professor Moriarty.
Madam Chair and Senator Pappas, thank you very much for the question. As you're well aware, as author, the Department of Corrections has had a bill for the Indeterminate Sentence Review Board or Release Board for close to 4 years now. And when we first drafted this bill, we had contemplated something we call the Juvenile Review Board. And we began conversations with the department, who said, you know, why are we not doing this together? Why are we not melding the two? Mm-hmm. But because that bill had already moved through the process, I believe it had already passed at least one committee in the House, and it had been in progress for several years, we didn't want to amend that bill itself. Instead, we tried to incorporate the provisions of your bill into this bill with a few distinctions for juvenile cases. And the main distinctions really are after reviewing the cases of adults, there would be 2 additional members that would join the board who had expertise in adolescent brain development, as Senator Latz just discussed, who could provide some context for exactly why neurologically what happened at the time. And so there shouldn't be substantial differences between the process at all. It'll be the same board.
That's my question. Is it
Yeah.
the same board?
That, I could have answered that a while
Yeah.
ago. Thank you. It is the same board with 2 additional members.
Madam Chair.
Senator Pappas.
Just procedurally, so I just had that bill just this morning in state and local government. It had it sent back here. So is the plan then, again, this will be incorporated into the omnibus and into an omnibus policy bill or into the omnibus funding bill, one of the 2, or into the one I'm supposed to be doing or the one you're doing, or just kind of confused here?
I think the specific omnibus bill is to be determined.
To be
but-
determined. Okay. Great.
Yeah.
All right.
There's a
Thanks.
fiscal note.
It is indeterminate.
Indeterminate. Right. All right. Thank you.
Senator Latz, anything else?
No, Madam Chair. So I move that Senate File 1325 as amended be recommended to pass and be re-referred to the Senate Committee on State and Local Government and Veterans Affairs.
Thank you, Senator Latz. All those in favor, say aye.
Aye.
Opposed? Okay, the motion is adopted.
Madam Chair, I'm sorry, I have another question. So we already voted
Senator
that out.
Pappas.
So if the state and local government already approved the board, then is there other language in here that, that they would still need to approve? Or I don't see exactly why it needs to go there.
Well, Madam Chair, the board's,
Senator Latz.
Senator Pappas, the board is slightly different in membership, but what we could do, since they are meeting right next door, they might still be there. I can go over and ask the chair if she needs to see this again. And if they don't, we can just hold it over. But either way, the idea, I think, is the dual track that Mr. Back has described for the MRRA bills is state and local can look at it if they'd like to, if they make any changes to it.
I'm
we can
sure she-
factor that in.
Madam Chair.
Senator
I'm sure
Pappas.
she'd prefer not to have it back again with, when it has such a minor change. But go ahead and ask. Thank you.
Thank you. Okay, thank you. Stick around, because if they're still meeting, or they might, she might want to talk with you and decide whether to keep it. Okay, I'll go over as soon as I can.
Senator Latz, are you going across now? We have Senator Champion here.
That was my question. If he's ready to go, I'll go talk to Senator Murphy.
Okay, sounds good.
Thank you.
So, Madam Chair,
Senator Champion, we have a Senate File 1164 before us.
yes.
Okay, when you're ready.
Great if we could do that one first. So you want me to start, Madam?
Yes, Senator Champion.
Okay, thank you. Madam Chair and committee, before you is Senate File 1164. And the purpose of this is really around background checks. We know that there are background studies conducted by the Department of Human Services. Those records are reviewed, and the commissioner and the agency makes determinations as to whether someone should be able to have direct care or provide services to individuals who they consider vulnerable or individuals that would need support services. And in this particular ask, for the purpose of this chapter, we are asking that a delinquency petition is proven in juvenile court for an individual certified as an adult shall be considered an adult for these purposes. That's just to clarify things, but if there's a finding of a proven delinquency petition in juvenile court for an individual who was not certified as an adult, shall disqualify the individual from direct contact services under this chapter for 5 years beginning, and it kind of lays it out. One of the reasons for that is because we do think that there should be some limitation and some clarification as to when a young person or someone who was a young person at one time ended up getting in some trouble, and then that issue was dealt with. We don't want them to forever be discharged or prevented from being able to serve or provide services to the Department of Corrections. This is also a byproduct of a task force that was put together, and there was a cross-section of people that were part of this task force and came up with these things. Then you also see that there's time limits for even 15-year disqualifications, and we added some new things under that provision. But again, it is to give everyone some guidance as to when you should count these things and when those things should no longer prevent a person from being able to provide services. One of the other things that you'll see is that we did remove under 3.9 and 3.10 this notion of controlled substances, because we recognize that a number of different people may have picked up some cases when they were chemically dependent. And so we don't want folks from Adult and Teen Challenge and others that have gone through and gotten treatment and gotten their selves together to be prevented from being able to provide some services to the department once they got their lives together. You also see on page 4.3, there's a 5-year disqualification, and it sort of outlines what those things are. And again, this bill is a byproduct of some work that has been done by a number of different stakeholders that were part of the task force. Last but certainly not least, on page 6.6, you will see that the commissioner may set aside a grant a variance for any disqualification that is based on conduct or conviction in an individual's juvenile record. And again, that is so that there's some clarity that when a young person did something that they're not supposed to and they turned their life around, we want them to be able to have an opportunity to go forward. So that's what this is all about. And I will stand for any questions.
Thank you, Senator Champion. Questions? Okay, seeing none. Any final words, Senator Champion?
No, thank you.
With that, Senator Pappas moves that Senate File 1164 be recommended to pass and re-referred to the Committee on Health and Human Services. All those in favor say aye. Aye. Opposed? No. Okay, the motion passes. And next we will do Senate File 2055, Clean Slate Act. Senator Champion, when you're ready.
Thank you so very much. Madam Chair, I know that I had some testifiers from the County Attorneys Association that was going to be with me, but I understand that they're out a little way, so I'm going to go forward because I think I want to respect your time. This is what we call the Clean Slate Act, and this is an expungement without a petition. And what this does, that we recognize that there are certain offenses, certain situations where individuals should not have to go through the expungement process, filing the petition, incurring costs under 609A, and that there are ways that you can utilize the services of the BCA and see if certain individuals that had certain things on their record were no longer doing things that would be challenging, and those things should be available for dismissal. So if you look under Section 1, Subdivision 1, a person who is subject to this eligible grant of expungement relief without filing a petition, that would be a person who was arrested and all charges were dismissed, for an example. If you look at 2, upon dismissal and discharge of proceedings against a person under Minnesota Statute 152.18, if a matter was resolved in favor of that person, but we also make it clear that for purposes of this chapter, a verdict of not guilty by reason of mental illness is not a resolution in favor of the person, so we don't want any confusion there. We also outline some things under Subdivision 2, which is around eligibility and diversion and stay of adjudications, that a person is eligible for a grant of expungement relief if the person has successfully completed the terms of diversion or state of adjudication for a qualifying offense and is not a felony, that is not a felony and has not been petitioned or charged with a new crime other than an offense that would be a petty misdemeanor for 1 year proceeding following completion of a diversion program or state of adjudication. We also recognize that sometimes people go through the pardon process, and when they go through the pardon process, that sometimes those records are still there for some reason. But under subdivision 3, we say a person is eligible for grant of expungement relief if the person receives a pardon extraordinary under chapter 638. We also looked at under subdivision 4, a person is eligible for grant of expungement relief if the person was convicted of a qualifying crime, has not been convicted of a new crime, there's been a waiting period that has been satisfied for a consecutive period of time immediately preceding a subsequent review performed that is equal to that is equal to or greater than the applicable waiting period, and is not charged with a new offense. So it goes back to that same language that we believe to be important. And if you look and see, as used in subdivision, qualifying offense means a conviction for any petty misdemeanor other than a violation of a traffic regulation relating to the operation or parking. And then you'll see some misdemeanors there. Now, one thing you should note, Madam Chair and the committee, that if you continue to look under this section of, if you go beyond 2.32, it also lays out a number of other things that would be eligible or not eligible. So if you look at 2.29, it says any misdemeanor offense other than. So if there was a misdemeanor offense, if you keep going under from 2.29 all the way to 4.14, that you will see those things that would or would not be eligible. And if you look under subdivision 5, if you look at 4.19, there's the notice, and that the court shall notify a person who may be eligible for automatic expungement under this section to the degree possible. They could either do it at a hearing when the court dismisses and discharges a proceeding against the person, or find some other way by which to notify them. And of course, I see Mark Hasse has joined me. So if there's anything I'm missing, I'll also let him pick this up as well. Notice can also be provided to the extent possible by prosecutors and defense attorneys and others. And we also want to clarify that if any person, if you look at 4.29, if any person gives notification under this subdivision, the notification shall inform the person and kind of tell you what that person should be told. But also you see the involvement of the Bureau of Criminal Apprehension at line 5.8, which is subdivision 6. So the BCA shall identify any records that qualify for a grant of expungement relief pursuant to this subdivision. They should make, and the BCA will make the initial determination of eligibility within 30 days. So you go to the BCA, you run your fingerprints, you do all that is to be done. The BCA is able to tell you if you are eligible or not eligible, and I'll let Mark Hasse pick up from there.
Thank you, Senator Champion, for the very thorough explanation. We do need to adopt the author's amendment. So with that, Senator Pappas moves the adoption of the A2 amendment. It's an author's amendment. All those in favor, say aye. Aye. Opposed? No. Okay, the motion's adopted. And would you like to move to your testifiers?
Yes. So Mark Hasse is going to do some other high-level talk about the bill and.
Thank you, Senator Champion. Mark Hasse, you may begin. Please state your full name and title for the record.
Thank you, Madam Chair. My name is Mark Hasse. Last name is Haase. I'm an Assistant Ramsey County Attorney. I'm also representing the Minnesota County Attorneys Association, which supports this bill. Thank you, Senator Champion, for carrying this important legislation. It's nice to be here with you again. I think it's about 10 years ago we worked on some expungement legislation. I can continue with the walkthrough of the bill at a high level, and I can answer questions that members might have. I don't have the the amendment in front of me.
We'll get that to you.
Yeah, but I'll pull out a few high points, starting off where Senator Champion left. One thing I want to point out is at 5.1, these records are still available for the purposes of a DHS background study. I know that some will find that to be important. Thank you. So starting at subdivision 6 of this section, these provisions are about the requirement that the Bureau of Criminal Apprehension will notify eligible persons, and they'll initiate the expungement by reviewing their records. And so the person will not have to apply. That's why it's automatic. Moving on to page 6, an important provision here is starting at 6.6. Law enforcement agencies would be notified.
Sorry to interrupt. Did you get the latest copy of the delete all?
Thank you, Madam Chair. Let me start there, find my place.
And this came from the majority leader.
Yep. Okay, this would be at 5.31. The BCA notifies law enforcement agencies that the record has been expunged, and because of the large amount of work that would be involved for the law enforcement agency to actually seal those records, what will happen is they'll get notice that it's been sealed, and if they get a request from, for example, an employer or somebody to get access to a record, then they can check the BCA database, which is created through the statute. The BCA will create a database that holds all these expunged records. The law enforcement agency can check that record and then just not disclose that record. And that really saves law enforcement agencies a lot of time for what's a pretty big change here. Moving on to the next page. One important point here, subdivision 7, that makes sure that the immunity liabilities for employers for hiring somebody with a criminal record that could attach, that were in the original expungement statute, also applies to these automatic records. And I'd note that the Greater Twin Cities or Minneapolis Chamber of Commerce supported in favor of this bill previously. Article 2, starting on page 7, makes some changes to the expungement by petition statute, which is the current statute. There are a couple of, one change is that it allows something that was, basically there's a process called stay of imposition. Somebody could be charged with a felony, and then it becomes a misdemeanor or a gross misdemeanor if they successfully complete probation. There was a Supreme Court case that made those ineligible under the statute. This change would make those eligible. The County Attorneys Association asked that waiting period remain a 5-year waiting period because of the underlying conduct, so that we'll have a 5-year waiting period even though it's ultimately a gross misdemeanor or a misdemeanor. And then there are a few felony offenses that have been added because these are pretty common. And again, this is for by petition, so the person would still have to petition, prosecutor would be notified, victims would be notified, and a judge would have to agree to expunge this. And the additions are at 8.8, third-degree controlled substance possession and fourth-degree controlled substance possession. And at 9.6, possession of shoplifting gear, and at 9.19, burglary in the third degree, which is essentially burglary entering an unoccupied, non-dwelling unit type of building, like a warehouse or something like that. And then possession of burglary or theft tools. I think we're getting close to the end here. Note that at 10.24, Well, the effective date for the petition by expungement is July 1, 2023. Did you cover effective date for the rest of the bill?
I did not.
The automatic expungement effective date is 2025, to give the BCA and courts and others ample time to get this work done and get ready for this. And then Article 3 is just conforming changes. So I will remain for questions.
Thank you, Mr. Haase. Am I pronouncing your last name correctly?
Yes, thank you.
Thank you for that walkthrough. Seeing no questions, Senator Limmer.
Thank you. Senator Champion, I'm trying to review this quickly, this delete everything amendment as it came before us. The question I had is it correct that if someone wants to file a petition to expunge records, they can get that directed to the Commissioner of Human Services and the Professional Educator Licensing and Standard Board? And can those organizations grant that expungement?
I can take
Mr. Haase or
Madam
Senator
Chair,
Champion?
I let Mr. Haase answer that one.
Mr. Haase.
Thank you, Madam Chair and Senator Limmer. What that does, if you could point me to the line, if
That's on page 4.
Yep.
Senator Limmer.
29 through 31.
Mr. Haase.
Thank you, Madam Chair. Yes. So what that does, Senator Limmer, because on an automatic expungement, which is this first section, it exempts the Department of Human Services for a background check and the Educator Licensing Board. So those automatic expungement will not apply to those bodies. And this paragraph 2 at 4.29 is really just clarifying language that the person could still seek those records sealed there through a petition to the court. But that way the court has some oversight. You know, there's a little more checks and balances if they're going to ask to have those DHS or Educator Licensing Board's records, sealed for those purposes.
Madam Chair?
Senator Champion.
And just for further clarification, currently right now, if you want executive branch records expunged, you have to go through Minnesota Statute 609A and petition the court, and you have to notify the commissioner and everyone else, and they have an opportunity to come in and speak. Those records cannot be just automatically expunged. So that's why they just wanted to make sure that clarity is there, because that's what the current law is. And in fact, we just did a bill where it was clear that the department would have to be notified and have an opportunity to come in and speak. Those things just can't automatically be done.
Senator Limmer.
Madam Chair, I see on the next page, on page 5, the BCA can make initial determination. It can identify individuals. And on line 16, grant expungement relief to qualifying persons and seal records. Is there any chance that a prosecuting attorney would weigh in on that advice?
Mr. Haase.
Madam Chair, Senator Limmer, there is not a provision in the automatic expungement in this new legislation for the prosecutor to intervene. This would be a large number of records, and there's just, the other checks and balances are in place here, the waiting periods, the type of offenses that qualify. So the answer is no.
Madam Chair.
Senator Limmer.
I guess I'm a little suspicious when someone says automatic expungement, and what kind of checks and balances do we have with an automatic process?
So, Madam Chair, if
Senator
I can,
Champion.
So Senator Limmer, when the body got together in order to think about, in order to support this legislation, as
what
you
body?
know, county attorneys and all the others, right? There was a cross-section of people who worked together on this Clean Slate Act. And when they got together, you will see that in the front there are eligible low-level automatic expungements that can only be done after going through the process of you going to the BCA, them running your fingerprints, them confirming a number of things. So that's why you see in the beginning, as I talked about eligibility, certain things that, certain offenses that a person would be able to get automatically expunged. And that also starts at 1.16. Dismissal, a person who's subject of a criminal record or delinquency record is eligible for a grant without the filing, and it goes to a number of those lower level
Senator
things.
Champion, sorry, just to interrupt, are you referencing the delete all?
Yes, let's see. The delete all is the same there, yes. So if you look at the delete all, you will see on page 1.6, it has a number of eligibility criteria laid out. And it's very clear, like for an example, a person was arrested and all charges were dismissed after a case was filed unless a dismissal was based on a finding that the defendant was incompetent to proceed. So if someone was arrested and all charges were dismissed, that would be eligibility, but the BCA would have to double check and make sure that they have not had any subsequent charges or convictions in order to be eligible. If you also look at number 2, they do say upon the dismissal and discharge of proceedings against a person under section 152.18, that's that stay of adjudication and where a felony decays to decays down to a misdemeanor. For possession of a controlled substance, though, is very limited because there's a belief that a number of people that may have addiction issues, that's where they have gotten arrested for possession of a controlled substance, but it was dismissed or discharged based on 152.18. And then they give a couple other notions that I think are important. If all proceeding actions or proceedings were resolved in favor of the person, if a person receives a favorable outcome because of a Rule 20, which is a competency notion, that would not apply. So it has to be on the merits somehow and not just because a person has said there's a mental health issue. So again, and then it goes through the diversion and stay of adjudications, a pardon. Those are the things that are referenced, Senator Limmer. I know that's a long answer, but I thought I should sort of lay that out.
Thank you, Senator Champion. And if folks saw the Clean Slate Act one-pager that's in front of you, just some of those groups that Senator Champion mentioned, ACLU, Minnesota, Minnesota County Attorneys Association, the Center for Victims of Torture are all listed on there. Senator Limmer, did you have any follow-up?
The only comment I have is that I think up until now, automatic expungement is not present in our system. One, I believe, has to petition the court, seek a hearing or at least a notice to the court. I think prosecutors have to be involved and make recommendation or an agreement with the court that an expungement could be available to the petitioner. And this is bypassing quite a bit of that. Even down to the point of having the Bureau of Criminal Apprehension grant the expungement. And I think they would only, they're rather distant from where the petitioner is and that jurisdiction of where that person comes from, as well as they may not know the intimate details of that individual like a judge may know. So I think this is a kind of a rough form of granting expungements in an automatic setting. I suppose it's justified because some of these are minor offenses, but nevertheless, I don't know how you really get around. You don't get a full picture of the individual petitioner, I think, in this plan, simply because you're not going back to the judge of original jurisdiction.
So,
Senator Champion.
Senator Limber, thank you for your thoughts there. So just so we're clear, under Minnesota statute section 609A, you still don't go back to the judge of record. It's usually on the expungement calendar, and there is information that has been provided, a notice has been provided to the Attorney General's office, the police departments, all of them, and it also, and the prosecution, right? So if it's like a misdemeanor, it's usually something that would go to the city attorney's office. What has been clear and of concern, even amongst the judicial officers, plural, is that there are certain things that they believe should be done automatically and not have to go through the process of paying a fee and doing all the work if it's low level and it's things that can be disposed of immediately. As you know, Senator Limmer, you don't get like a stay of adjudication or a stay of imposition if you have any criminal record. They don't like to do that. They will not do that at all. So that's why there's that provision for those individuals, and then the waiting timeline where still there's an amount of time that you have to wait to even go in and ask the BCA to do it. Now, lastly, about the BCA, that's usually where people go to get their records, even for expungements. You go to the BCA, they run all your records, you rely on that information because the BCA not only has records of Minnesota, they can pull records from other places as well. So they want to really make sure that you don't have anything throughout, right? And not just in the state of Minnesota. So that's why the BCA is also involved. But we think that this has the guardrails that we all would need, especially for low-level offenses. But in the event there's something much more serious, that will require a petition and to go through that other lengthy and expensive process. Did I miss anything?
Mr. Hasse.
Madam Chair, I would just add that Senator Limmer, when the County Attorneys Association agreed to support this bill, working with the authors very closely, it was because it's our position that there are no offenses on here that, you know, with the waiting period and the crime fear period, there's any concern, the types of concerns you're raising. I mean, if you look at these lists, it excludes any types of violence, you know, violations of order for protection, any type of sexual conduct, higher level theft, for, you know, those types of things. That was something that the county attorneys really wanted. If there were things that, you know, really we felt should have a judicial review, we asked to have those kept in here and in the, at least the petition, or not eligible at all. And that's where the association, you know, got their comfort level with this.
Okay, seeing no other questions, Senator Champion.
I have no further notions. Thank you, Madam Chair.
Madam Chair.
Senator Kroon.
Thank you, Madam Chair. I'm just going to note for the record that this delete everything 20-page author's amendment was printed yesterday at 6:37 p.m. I didn't see it until right when the bill was introduced at 2:30. I'm wondering if there's any reason this wasn't distributed earlier.
Senator Kroon, my understanding is that the amendments would have been posted at the time they were printed, but I'd have to consult with staff a little bit longer to get you an exact answer.
Madam Chair.
Senator Kroon.
Thank you. I don't believe they were posted.
We're going to check for the committee.
Why did you go to delete all this? It's just small amendments within the House.
We did a bunch of small amendments. That's why, like, two different committees. One of them was attached to the next one had everything been added in. One Senator Long wanted to get it in the same shape.
That's a bad idea because it always makes them feel like there's something else missing when you delete all of them like that. doing something major when you could have done something just because it's small things that you wanted to change.
While we're checking, Senator Champion, do you know where this bill's headed?
I don't think so. Madam Chair, to the question.
Yes, Senator Champion.
It's my understanding that it may be laid over for possible inclusion, or is it going to finance and we have to find some other way to pay for it? What's the fiscal on this? Because there's yeah, but I wish you got that said, kind of told me like where you needed to go, because I thought at one time Jamie was thinking about it traveling on his own, but you got to think of always coming for less money.
Yeah, that was the original hope.
I think you should go to just finance where you have to figure out where the money's going to come from.
Do you want to see if Chaz has anything to say? See if Chaz has anything to say?
Do you have a sense of where the bill is going to go with?
It's my understanding it's going to be laid over.
Yeah, because somebody like me could, right?
Yeah, exactly.
What's the fiscal note?
The fiscal note, actually, this isn't. It's actually just the BCA cost, so it's, it actually, so it's 3.7 and then 190. You want to take that? Yeah, but this isn't over, it's just the cost.
She's the lobbyist on this one. Chaz has been doing a lobbying on this.
They're going to remove the cost too. So it's only to the BCA.
So, Mr. Chair, maybe this might help. It's my understanding that there's no additional cost, if you're looking at the fiscal note. We understand now that there's no additional cost for State Patrol and no cost for DHS. The only cost that we have to figure out is with the BCA. So our hope is that we can lay it over for possible inclusion, and then we can get better sense of where the money's going to come from, because I know targets are always pretty stressed.
And Senator Champion, you're saying no cost to the State Patrol because that's a trunk highway fund expenditure?
Yes, I think so.
All right, so what we're going to do is lay the bill over for possible inclusion, and we'll sort out exactly what budget it comes out of some other time. We don't need to accomplish that right now, but if we send it somewhere, it's never going to surface again. So we're going to hang on to it, and we'll decide what budget covers it between now and next week.
Thank you. I almost said Your Honor. All right.
Wouldn't be the first time that mistake was made. And I've made the same mistake. All right, Senate File 1325 Senate File 2055 as amended is laid over for possible inclusion in our budget bill.
Thank you.
Now, we're going to bring, yeah, I don't need to be at the table for that. I'll just do that. What's my file number on that? All right, so members, we're going to bring Senate File 1325 back. This was the juvenile life without release bill relating to an indeterminate sentencing review board. We have consulted with the chair of state and local government and veterans committee, and because this is the board that's made it is almost identical to the board that they've already heard in Senator Pappas's bill. The chair of that committee has decided she does not need to see it. So we did send it there. So I'm going to entertain a motion from Senator, I was going to say Pappas because she had the other bill, but I don't see her. Senator Oumou Verbeten moves that Senate File 1325 that the motion by which Senate File 1325 was recommended to pass and re-referred to state and local government be reconsidered at this time. All those in favor say aye. 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 Opposed? A motion prevails. Now we have Senate File 1325 before us. We are going to lay over Senate File 1325 for possible inclusion in our budget bill. So, Senator Maye Quade, are you ready?
Thank you.
Mr. Chairman.
Senator Limmer.
Mr. Chairman, did you say Senate File 1395? Did I hear
Next
you wrong?
bill that we are taking up is Senate File 63.
All right.
So Senate File 63, having been laid on the table at the conclusion of the previous hearing in this committee, is now taken from the table and before us for consideration. Senator Oumou Verbeten.
Thank you, Mr. Chair. I move that Senate File 63, as amended by this committee on Friday, February 10th, 2023, be recommended to pass.
Is there any discussion on the motion? Hearing none, seeing none, all in favor say aye. 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 Opposed? Motion prevails. Next file before us is Senate File 1394, Senator Maye Quade's bill as well. Staff will distribute the packets to the members. Senator Maye Quade, Senate File 1394 on deepfake images and technology. Please describe your bill.
Thank you, Mr. Chair and members of the committee. I'm here today to urge that the legislature address the issue of deepfakes, in particular those that depict sexual content or are used to influence the outcome of an election. Deepfakes are synthetic media that use advanced artificial intelligence techniques to manipulate video or audio content. These technologies make it possible to create highly realistic, yet completely false depictions of people doing and saying things that never actually happened. This has serious implications for privacy, free speech, and the integrity of our elections. And Mr. Chair, with your permission, I'd like to share a short clip with the committee to demonstrate what deepfakes are.
Go ahead, Senator Maye Quade.
Should it appear up there, Mr. Chair? Or can you see it down there? No. Okay.
Our enemies can make it look like anyone is saying anything at any point in time, even if they would never say those things. So, for instance, they could have me say things like, I don't know, Killmonger was right. Now, you see, I would never say these things, at least not in a public address, but someone else would. Someone like Jordan Peele. This is a dangerous time. Moving forward, we need to be more vigilant with what we trust from the internet.
Mr. Chair, one of the most concerning applications of deepfakes is the creation of non-consensual sexual content, which is commonly referred to as revenge porn. This is a serious violation of privacy and can cause significant harm to individuals portrayed in the content. In many cases, the victim is unaware that the content exists and may only discover it after it has been widely shared online. Another area of concern is the use of deepfakes in political propaganda and election interference. With the increasing sophistication of these technologies, it has become easier to create convincing fake news or propaganda that is designed to manipulate public opinion. And this could have potentially serious impacts on the outcomes of elections, undermining the integrity of our democratic process. To address these challenges, I believe that it is necessary for legislation to be enacted to regulate the distribution of deepfakes. This issue is a serious and growing concern that demands immediate attention, and I urge this committee to take steps to protect the privacy, free speech, and democratic rights of all citizens. Members, everything that I just said before that was actually generated by AI. I typed into the search bar, write an opening statement for legislation regulating deepfakes. The video that I showed you was created 5 years ago by actor, producer, writer Jordan Peele, who used a considerable amount of technology to create a deepfake of President Obama, but today that technology exists where you could do it very easily in your own home. This legislation is very, very important for all of us in the state and hopefully in this country. Deepfakes are on the precipice of becoming more common and more regular. And so you're not going to find me in front of this committee very often arguing to create crimes or punishment for things that people do. However, this is a very specific instance where action by the legislature can stop people from starting to do this. This is not something we've seen yet, and we could prohibit it or we could stop it before it starts. Mr. Chair, with your permission, I'd like to get the bill in the order that would be most appropriate. There is an amendment.
So members, the A5 amendment is part of the packet. This bill was heard by the Elections Committee, so it's back in front of us now. This is not the committee of first hearing, so this is not an author's amendment. Senator Maye Quade, will you please explain the content of your amendment to us?
Yes, Mr. Chair and members of the committee. So this amendment takes into consideration a lot of input, namely by the Motion Picture Association and the newspaper organizations, to make sure that the behavior that we're going after in this bill are people who create deepfakes and not, say, a news organization that puts a commercial on television depicting a candidate doing something they didn't actually do, or infringing on First Amendment rights. So you'll see in here, dissemination involves parody, satire, commentary, criticism. We clarify the language about it being so realistic that a reasonable person would believe it depicts. New York and California have passed similar laws, and so a lot of these recommendations are keeping in line with those bills.
Are there any questions or discussion from members of the committee relating to the A5 amendment? Not seeing any. Senator Oumou Verbeten moves adoption of the A5 amendment. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment is adopted. Senator Maye Quade.
Thank you, Mr. Chair. I think the bill stands for itself. One of the things I want to note is that it is bipartisan, and I want to thank my co-authors, Senator Lucero, Senator Limmer, Senator Dibble, and Senator Gustafson, for joining me on this bill. Senator Lucero, when he was in the other body, worked a lot on bills like this, and we joined together, so I want to thank him in particular for his expertise. The only other thing I'll say is that there was a conversation in the Elections Committee about increasing the penalty for creation and dissemination of a deep fake during an election to more than $1,000, but we would have had to increase the crime to being a felony in order to get it to where we had that conversation. And so I have some follow-up to do with a member from that committee to just make sure that we're on the same page, but that's the only other piece of information that I would share with the committee. I'm open for questions.
Any questions or discussion? Senator Limmer.
Thank you, Mr. Chairman. Senator Maye Quade, I'm looking through the bill and I see there is injunctive relief that could happen. Is there, sometimes when we make, we set parameters for the liability that is recognized. I don't see that here, or punitive damages written in. Is there a reason why? That I see that there are some criminal penalties, but I would imagine this could be quite damaging to someone's reputation, or you know, could cause a dissolution of marriage, or a partnership in a corporation, or a commanding, let's say, a person who has an executive role in a large corporation. It could affect stocks values, and so could you explain, I guess I'm, maybe not explain, but the question is why aren't we recognizing a broader in court relief for a liability, for the possibility of a lawsuit?
Senator Maye Quade.
Thank you, Mr. Chair and Senator Limmer. My short answer for you is I think without having concrete real-world examples to point to say, here is an example of harm that was done with a deep fake, and so that's kind of setting the container for what kind of damages we could put into this bill. That is why, but I do believe on line 3.3, we do go into kind of the financial losses that could be due to a dissemination of a deep fake, but the reason why it's not maybe more in the injunctive relief part is because we're trying to stop it from starting instead of addressing something that's currently happening. or currently harming people in a broad way. Did I answer your question, Senator Limmer?
Kind of.
Senator Limmer. Senator Westland.
I was just going to, if you look at the damages section, it does provide 3.3 on general and special damages, including all financial losses due to the dissemination, an amount equal to any profit made from the dissemination, and so on. So I think that that section actually does deal with more significant potential damages.
Mr. Chair,
Senator Limmer.
in that same area, I see on line 7, 3.7, civil penalty awarded up to an amount of $10,000. To me, $10,000 is pretty puny. And I, quite honestly, if you begin to study a little bit of the artificial intelligence that's coming at us, this is going to be a major issue in misrepresentation of individuals. It's not limited to, well, you have a reference here on campaign elections, but this is going to affect anything and everything. And I think we really need to set a stake in the ground for very serious use of this type of false representation. I'm a co-author on the bill. I like where the bill's going. I just had hoped that maybe that there would be a more expansive role of civil lawsuit to control this.
Mr. Chair.
But having said that, I'll still vote for the bill. We'll get it rolling, and it's a work in progress, I think.
Senator Maye Quade.
Thank you, Mr. Chair, and Senator Limmer. Absolutely open to working with you on what that could look like and what civil penalties could be. I'm very, very open to changes to this bill because you're right. The things that are coming at us are, it's like the don't believe your lying eyes scenario, right? It's very, very harmful. And so I'd be happy to talk with you about what we could change to that might make you feel more comfortable, because I think we all want to feel good about this bill.
Senator Maye Quade, where would you like the bill to go from here? I don't see any state fiscal impact here, so it's not a budget bill.
Mr. Chair, and it's already been 2 elections. I think it is your call if you would like to keep it for your omnibus or send it to the floor. I'd be happy to send it to the floor. I believe that's what's happening in the House. Excuse me, the other body.
Well, why don't we send it to the floor, and then we can make a judgment call later if we want to also include the content in an omnibus policy bill.
That sounds great.
Senator Limmer.
Just to raise one last question, I see the word on 3.13, the use of the word confidential. Court shall allow confidential filings. Those of us in data practice, the word confidential triggers use of art. It's a classification of data. I don't know in this case that it is used in the same manner, but perhaps counsel could just clarify a little bit that use of that word.
Ms. Primo.
Mr. Chair and members, it has a different meaning in this context than the Data Practices Act. The judicial branch is not subject to the Data Practices Act, and they have their own rules where they provide for confidential filings under, I think, Rule 11 of the General Practice Rules.
Not seeing any further discussion. Senator Limmer, would you like to make this motion? Senator Limmer moves that Senate File 1394 as amended be recommended to pass and be sent to the Senate floor. All those in favor say aye. Aye. Opposed? Motion prevails. Thank you, Senator Maye Quade.
Thank you, Mr. Chair.
I think Senator Mohamed has arrived. Is that true? Members, we'll next take up Senate File 691, Senator Mohamed, relating to crimes motivated by bias reporting. Senator Mohamed, welcome to the Judiciary Committee. It appears that your testifier has joined you at the table, which is great. Senator Mohamed, why don't you introduce yourself, or you tell us about your bill.
Thank you, Mr. Chair. It is wonderful to be back in one of my favorite committees here. Mr. Chair, I'd like to start by offering the A1 amendment, which is an author's amendment.
Members, in your packet is the A1 amendment. This is the first committee to hear the bill. Senator Oumou Verbeten, a co-author on the bill, moves adoption of the A1 amendment. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment is adopted. Senator Mohamed.
Thank you, Mr. Chair. Before you is Senate File 691. Members, hate crimes are on the rise, but combating hate requires us to identify it. This bill is the first step in doing that. Senate File 691 will improve our reporting of hate crimes in Minnesota, as well as update the training that the Post Board receives for recognizing, responding, and reporting crimes. The FBI has reported a nationwide increase in hate crime incidents in recent years. Yet, here in Minnesota, official statistics severely undercount the true number of incidents. The current statute, which only allows for law enforcement agencies to report incidents of hate, creates a discrepancy between the statistics reported and how many hate and bias incidents actually occur. Senate File 691 will provide the training that law enforcement officers need to properly identify hate crimes, and it will also allow community organizations to collaborate with the Department of Human Rights to collect more accurate data around these incidents. More accurate data will also allow us to have a better understanding of how prominent the problem actually is in Minnesota. Senate File 691 would make hate crime data collections in the state more inclusive too. By involving communities, creating mechanisms for community-based reporting, and also providing an avenue for community organizations to report to the Department of Human Rights, this bill is designed to help address the fact that the current approach and resulting data do not fully capture the experiences of so many of the people who are disproportionately impacted by hate crimes. Members, there's no room for hate or discrimination in Minnesota. Thank you, Mr. Chair, and I'd like to offer some time to my testifier, Brandon Schorsch.
Thank you, Mr. Schorsch. Why don't you go ahead and introduce yourself, state your affiliation, if any, and present us with your testimony.
Wonderful. Thank you, Mr. Chair, and thank you, Senator Mohamed and members of the committee. My name is Brandon Schorsch. I'm an organizer at Jewish Community Action, and I'm also here on behalf of the Communities Combating Hate Coalition. Our coalition began in 2019 with conversations between just a handful of Muslim, Jewish, and LGBTQ advocacy groups, as we noted serious issues in the responses to several prominent hate-motivated incidents, most notably the attempted firebombing of Dar al-Farouk in Bloomington. Since then, our coalition has grown to 18 member organizations, and in our efforts to understand the problem, we recognize the need for significant revisions to Minnesota's outdated hate, or as we know them, bias crime statutes. Our time is limited, so what should legislators know? 2/3 of criminal hate acts go unreported. This is according to numerous statements from the FBI, national law enforcement associations, and civil rights organizations alike. Crime data is reported voluntarily, and many jurisdictions never report or withhold reports to avoid bad press. Again, this is something the FBI has noted on numerous occasions. It's also important to note that all crime data that we use, uniform crime reports, are based off allegations, not prosecutions. Police departments are the sole source for data, but officers are not legal or constitutional experts. They have a lot of other jobs, a lot of other duties, so many don't know how to recognize when a criminal act has a bias component. Reported hate crimes have been increasing every year, with each year of the last several setting records. And other countries have better reporting systems because they work directly with communities affected and build standardizations for reporting to sift out bad data. Better data lets our communities better see what problems are. To close with a public health example, in 1854, a wave of cholera hit London, and a researcher named John Snow began to map out the cases, and he found that the cholera hotspots were all near specific wells that turned out to be contaminated with human waste. The use of mapping and aggregated data is a cornerstone of public health and all other forms of public policy today. With the provisions of this bill, the state of Minnesota will be better equipped to respond to hate holistically rather than solely through criminal law as it mostly does today. Thank you.
Thank you, Mr. Schorsch. We also have on the testifier list Beth Gendler. Mr. Schorsch, are you here on behalf of Ms. Gendler as well from Jewish Community Action?
Beth Gendler could not make it, so I'm here in her stead.
All right, thank you. Also on our testifier list is Erica Beigen from the ADL Midwest. Do we have Ms. Beigen available here or virtually?
I believe her testimony was meant to be written.
Members, in your packet, we do have a letter from David Goldenberg, the ADL Midwest Regional Director. I would assume that's the same organization, so refer you to that correspondence. Also on the testifier list, tentatively, is Kelly McCarthy, the Mendota Heights Police Chief. Is Chief McCarthy here? Not seeing Chief McCarthy here at this time either. Well, it appears we have gone through all of our live testimony on this bill. I will note that just on the radio today, I heard the ADL, National ADL, issued statistics that just since the last reporting period to the most recent reporting period, anti-Semitic incidents rose 40%. 40%, and they also found a concomitant increase in anti-Semitic attitudes among among people. So that's consistent with other information that has been public. Unfortunately, we live in an environment where it is happening more frequently, and it's not, of course, just anti-Semitism. It's a lot of other bias attitudes and incidents as well. So there was a time when I was the chief author on a previous version, at least, of this bill. I, in fact, had thought I had become a co-author on this bill, but it must have filled up too quickly because I didn't get on there.
It's a popular
but
bill.
I'm very pleased that there's broad support for this effort as well. And I agree with the need for evidence, data, statistics, so that we can identify, define problems, and then only from that can we formulate appropriate policies to try to address them. Is there any discussion among the committee members on Senate File 691? I'm not seeing any. Do we know where this bill goes from here? Is there a fiscal on it? Seems laid over.
Yeah, we laid it over. It has three positions. I think that there's some overlap between this and the governor's bill.
I believe in the House it got laid over, Chair. I believe in the House it got laid over.
Yeah, it was laid over in Judiciary this morning. Good.
So, Senator Mohamed, there is a fiscal impact to the bill. The bill anticipates creation of 3 positions within the Human Rights Department and also anticipates grants. The bill itself has blanks for the dollar amounts for the grants appropriation. Actually, there are 2 appropriations here. One is for support for victims of crimes bias, and one is for support for community organizations, and there's also a data collection provision, which is where the Human Rights Department staff and administrative costs come from. Do you have any dollar figures that you're specifically asking us to include in the bill?
Chair, I think we're still working that out. I don't have, do you guys have?
The House file version used, may I address the chair?
Yes, Mr. Schorsch, go ahead.
To my best knowledge, again, I am not a legislator, but as I've been following the House Companion does have fiscal notes attached to it now based off of the governor's proposed budget.
All right, so we'll be carrying whatever this is in this committee's budget, since the Human Rights Department and OJP, which will be administering the grants, are within our jurisdiction. So at this time, I think we should just lay it over for possible inclusion in our budget bill. So Senate File 691 as amended is laid over for possible inclusion. Thank you, members.
Thank you, Mr. Chair.
Senator Mohamed, don't go anywhere. You've got the next bill up as well, Senate File 2476.
I'll see you later. Thank you, Chair Latz.
And maybe I should ask, before we get too far past the last one, if there are any specific dollar amounts that are being requested other than what's in the other body's version of it, a department, or someone should come let us know.
I think Senate Representative Vang and I are talking, but I think we're asking for the same thing, and I think it aligns with what the governor is asking for.
Okay. Thank you, Senator Mohamed. All right, we have Senate File 2476 in front of us. This is coming to us from the Labor Committee. Council, it looks like the whole bill is within our jurisdiction. Is that right, Ms. Primo? Yes, that is correct. Senator Mohamed, tell us what the bill does, please.
Thank you, Chair Latz. Before you is Senate File 2476, captive audience. This bill protects employees' freedom of conscience by prohibiting employers from forcing employees to listen to the employer's opinion about religion or politics, including whether an employee should or should not join a labor union. The scope of the bill does not apply to communications necessary for an employee to perform their job duties. You should have in your packets a letter of support from the Attorney General. The substance of this bill was heard in the Labor Committee. With that, I will cover Subdivision 2, remedies, which is the jurisdiction of this committee. Subdivision 2 allows employees to bring a civil action in district court against an employer who violates this section within 90 days of the alleged violation. The court may award the employee injunctive relief, reinstatement, payback, reestablishment of benefits, and other necessary relief deemed necessary to make the employee whole, including reasonable attorney fees. This is similar to other enforcement mechanisms in Chapter 181, which deals with employment matters. And with that, I will stand for questions, and I have a testifier with me, Brad Leto, who is the treasurer for the AFL-CIO.
Mr. Leto, welcome to the Judiciary Committee. Go ahead and introduce yourself and present us with your testimony.
Thank you, Mr. Chair. And good afternoon, Mr. Chair and members of the Senate Judiciary and Public Safety Committee. My name is Brad Leto, and I'm Secretary-Treasurer of the Minnesota AFL-CIO, collective voice of Minnesota's unions. The Minnesota AFL-CIO supports Senate File 2476, but of course I will limit my very brief remarks. Subdivision 2, the remedies portion of the bill, which Senator Mohamed mentioned that it's a private cause of action for an employee, similar to other provisions in 181. One example is the Equal Pay for Equal Work statute, 181.68. The bill, in part, provides adjunctive relief, reinstatement for employees' former position or equivalent position, back pay, seniority, etc. Bill also requires attorney's fees. Requiring the award of attorney's fees gives teeth to the enforcement of this bill. The promise of attorney fees is what permits attorneys to represent workers who have lost their source of income due to not going an employer-recorded meeting that is not job-related. And I would just say that if, I know some people have mentioned that the attorney fees, it's a difficult thing. Some people have mentioned there's not enough guardrails on excessive attorney fees. Well, it's all subject to a court's review of reasonableness, which you likely know, and attorneys must demonstrate their hourly rates are reasonable, time expended is reasonable, as well as overall award is reasonable. I know it's, there's case law, Hensley versus Eckert, 1983, and then additional factors. The court must consider time and labor required, quote, time and labor required, nature and difficulty of the responsibility assumed, the amount involved, and the result obtained, the fees customarily charged for similar services, the expense, reputation, and ability of counsel, and the fee arrangement existing between counsel and client. Milner versus Farmers, Insurance Exchange, and then also State versus Paulson. Thus the court's already ensured that attorney fees are not excessive. So that would conclude my testimony, and I'd stand for questions. Thank you.
Thank you. Senator Mohamed, I do have one question for you relating to the effective date. Line 2.25 makes the bill effective the day following final enactment. Can you explain why the urgency on that as opposed to our usual practice with a later effective date?
That is a good question, Chair Latz.
Well, Mr. Chair, Senators, obviously we'd like the quickest effective date as we could, and if you want to, I would hate to see August 1st, but I certainly would leave it up to the committee. But the reason was basically that to try and get this is in place as quickly as possible. But that's so.
So one concern I would have is there are requirements in here to post notices.
True.
There are deadlines for bringing civil action.
Right.
So information about that availability would need to be distributed and made available to employees. And if that time period is running after an early meeting is held and it's effective already, then they might not be able to actually learn about their rights, let alone implement them in time. So I'm just wondering if we ought to just, if we just strike the effective date section, there's automatic effective date, right, Ms. Primo? Or should we change the language in it?
Mr. Chair and members, I recommend also including an application clause that it applies to causes of action accruing on or after that date, whatever that date the committee chooses. So if you'd like the default August 1st, 2023, I think we should amend that in and use the application clause too.
That would be my suggestion, since we don't know exactly when this bill will become law. Might be the last day of session for all we know, and that would give at least about 60 days or so for information to be disseminated. Is that fair enough?
I'm
Senator
okay with
Mohamed?
that, Chair Latz.
Yes, Mr. Chair, that sounds good.
So Senator Oumou Verbeten, would you make that motion to adopt the language as Ms. Primo is going to specifically describe?
Yes, Mr. Chair, so moved.
Ms. Primo.
Mr. Chair and members, on line 2.25, delete the day following final enactment and insert August 1st, 2023, comma, and applies to causes of actions accruing on or after that date.
Any discussion on the amendment? Not seeing any. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment is adopted. Is there any further discussion on Senate File 2476? Senator Limmer.
Mr. Chairman, and Senator Mohamed, how would this work if the employer was a religious organization and up till now requires their employees to attend a religious service Are we changing that for a religious employer?
Chair Latz,
Senator Mohamed.
Senator Limmer, it does not. What it does is, the point of this, the goal of this bill is to make sure that when employers have meetings around religious or political things. For example, like if I am an employer and I have a meeting, but it's not mandatory, I will force my employees to come, and then all I will talk about is how they should not unionize. The goal of it is to say that should be voluntary, so employers can still hold any of those things that are in this bill. It just would not be required for the employee to attend.
So, Mr. Chair,
Senator Limmer.
Senator Mohamed, could you point to the portion in the Senate file that excludes a religious organization? I just need to see it in writing.
Senator Mohamed.
Chair Latz, Senator Limmer, section, or lines 2.16, 2.17. Limit the rights of an employer or its agent, representative, or designee from communicating to its employees any information that is necessary for the employee to perform their lawfully required job. So if that's part of their role and their job, they will still attend. But if it's not part of their job requirements, then it's voluntary.
Mr. Chair, if I might.
Mr. Leto.
On the, Senator Limmer, on that, basically, it's, the section does not prohibit that. So the limit, it does not limit the rights of an employer or its agent representative to communicate with any employees. There's a question in the other body, actually, on this subject, and they said, well, if it was a religious college or something like that, if you're an employee there, part of the job duty, you've talked about job duties, that if you're a religious organization, that's part of, it could include part of your job duties. In the case of like an employment situation, we've had instances in the workplace where employers have required people to pray. Not in a religious organization, and if they don't, they are kind of singled out. This was one situation. I'm not going to say who it was, but there was a situation of that happened, and also there was situations where employers were required and actually checked that that workers emailed or wrote letters on specific topics to the legislature, and so they actually checked on it. We had one facility down in southern Minnesota. At one point, the employer talked to them, had a series of meetings, and actually, and you could argue whether this is good or bad, but actually had them write letters in favor of capping lawsuits. And actually, the parent union said, we understand they did that. They had a series of meetings, but they did not. They said, we don't support that. No other union did. It was. So, anyways, those are some instances. But as far as if your job is with a religious organization or another organization, and that's part of your duties that you're working there, that's not covered.
So, Mr. Chairman,
Senator Limmer.
this seems to be focused just on employers. What about unions? Do unions require their members to attend a strike or to be at a particular meeting, a union meeting of sorts? I don't see union. It seems to be focused on employers, not unions. So are you excluded as a union from having the same standard as an employer?
Mr. Chair, if you and Senator Lumber, if you've gone to any of our union meetings, other than if it's I will just say, and I'm going to be honest here, if it's a contract situation, they will get a huge turnout, and they don't require them to come. But at a typical union meeting, it's not, generally, depending on the union, it's not a huge necessarily, and they're not required to come, but everything is voluntary. I mean, I will say that unions, and this is about organizing unions too, but along with other stuff. But unions, would say they are very democratic for the most part, and they've gotten much more so. So, anyways, they're not required to attend those meetings. I will say that depending on the topic of the union meeting, you get a large turnout or a very little turnout.
So, Mr. Chairman, the question I asked was, does this just apply to employers? And unions are excluded from this same treatment?
As far as mandatory meetings? I'm sorry, Mr. Chair, Senator.
A political meeting.
Senator Limmer, the bill is entitled Employer-Sponsored Meetings or Communication, so I'm not sure what your question is. Sounds more rhetorical. I will note there is definitely a unique relationship of potentially coercive mandates between an employer and an employee that doesn't exist in other circumstances.
Mr. Chairman,
Senator Limmer.
I at one time was a member of a union, and I went to my first union meeting, and the old guys were talking, and they asked for some comment. I got up and made my comment, and I was told to shut up and sit down. So I guess I have a little bit better flexibility here in the Minnesota Senate. But nevertheless, I'm just looking for some kind of parity. I started my questions out on a religious order of sorts, an employer, a pastor, or a nun, or a imam. If that particular employer that's focused on expanding their faith, and if someone is requested because of their position to be at a meeting regarding a religious issue, can they be excluded if this passes into law? Which would kind of denigrate the whole reason why they're hired for the job in the first place.
Chair Latz.
Senator Mohamed.
Senator Limmer, if the requirement of the job is for them to perform those duties and that's part of their job, then they have to go to that. But if it's not a part of their requirement, if it's not a part of their requirement to perform those things or to attend those meetings, then it's voluntary. That's the goal of the bill, is to say, if you're a religious organization, you're a rabbi or an imam, and your job is to perform this is part of your job requirement, then that is your part of your job requirement that you're going to attend. And that's not what this bill is saying. What this bill is saying, if an organization or business or anybody's having political meetings, religious meetings, and it's not a part of the employee's job duties, then that becomes voluntary, and it should not be required.
Is there any further discussion on Senate File 2476? Members, we are informed this bill is to be returned to the Labor Committee. Co-author Senator Seeberger moves that Senate File 2476 as amended, be recommended to pass and be re-referred to the Senate Committee on Labor. All those in favor say aye.
Aye.
Opposed? No. Motion prevails.
Thank you, Chair Latz, and thank you for accommodating me today.
We amended it, didn't we? Senator Kunish, Senate File 1661. Senator Kunish, Senate File 1661. Welcome back to the Judiciary Committee. Go
Thank
ahead and
you,
tell us about your bill.
Mr. Chair. Members, before you is Senate File 1661. This is a bill to provide the 11 tribal governments in Minnesota with the option of state funding to directly provide probationary supervision to their members. This proposal has had extensive consultation with tribes across the state and is central to ensuring more successful outcomes for public safety and the well-being of our communities throughout our state. And I should have Commissioner Schnell here. There he is. I will ask.
Commissioner Schnell is spending the day with us.
Oh.
Senator Kunish.
If Commissioner Schnell would like to testify now, that would be great.
Well, I assume we're going to be testifying to the bill.
Oh, I have an amendment too, I'm sorry.
Including the A1 amendment, which
Yes.
is an author's amendment here. So Senator Oumou Verbeten moves adoption of the A1 author's amendment. All those in favor say aye. Opposed? Motion prevails. The amendment's adopted.
Thank you.
Commissioner Schnell.
Good afternoon, Mr. Chair, members. It's a pleasure to be with you here today once again. Paul Schnell from the Department of Corrections. I want to, first of all, thank Senator Kunish for carrying this bill. The DOC, like all state agencies, engages in consultations with Minnesota tribes across the state. And through these consultations, we've heard from tribal leaders very real concerns about supervision outcomes for members of their tribe. Tribal leaders would like to integrate the services they provide their members with community supervision, and this is the essence of community corrections. Tribal leaders want better outcomes for their people, and through consultation, we share the belief that culturally relevant supervision services will produce better outcomes for Native American people with system involvement. For the past several years, it has been a priority for the administration to extend both the authority and funding to tribal governments so they can provide supervision services to their members. Senate File 1661 amends Minnesota law to authorize tribal governments to provide funding and supervision to their members if they choose to provide those services. Tribal governments electing to provide these services would be required to engage in the same processes as county jurisdictions, including the requirement to establish a citizen advisory group and to develop a comprehensive plan. This bill pairs with the governor's budget request of $2.75 million or $250,000 per tribe, so that tribal governments have these dollars for supervision services or providing supervision themselves or in collaboration with counties. Chair members, at this time, when our state works to develop strategic and sound, critical, needed investments and policies to guide Minnesota's community supervision system, it's right and timely for us to provide Minnesota's tribal governments the authority and funding to serve their members and our fellow Minnesotans to achieve better outcomes. This is good for the tribes, it is good for members of the communities they serve, and it is good for Minnesota and its public safety. With that, I would stand for any question you or the committee may have.
Do any members of the committee have questions or comments regarding Senate File 1661? Senator Limmer.
Mr. Chairman, in my visits to tribal communities this past few years, I visited with Native American judges in their tribal court business, and they assured me that they would like to continue with their tribal courts around civil matters, but criminal matters, they would rely on the county system. This is a little bit of a sidestep by moving out of a county organization and then moving under the auspices of a tribal community. And so the question I had is, has this been modeled anywhere else in the country? Are there other tribal communities that do this? And is there a direct relational effect to lowering of recidivism? I'd like to know what the goal might be, and I think maybe all of it, we should always focus on recidivism, and to get there would be some sort of rehabilitation, but do we have any signs of success anywhere?
Commissioner Schnell.
Mr. Chair, Senator Limmer, we don't have direct models for this. But that said, we do know that there is ample evidence that providing services in a manner that is reflective of the cultural significance does make a difference. And that certainly is a strong part of this. And as I would say, the essence of community corrections is the integration of services that are provided by within that local community and correctional services. That was the reason that Minnesota went to a community corrections model that happened to be grounded in county government. But the reality is that these tribal members enjoy both, they are both Minnesotans as well as members of that tribe and part of that respective tribal nation and government. I would also say that this really is not related to supervision of tribal matters. These are matters that are handled by state courts. I would also add that many of these tribes have really strong relationships with their county supervision entities. And I would note that this is supported by the MC work group, and it is included in their overall proposal related to supervision that has come before this body.
And may I, Mr.
Senator
Chair?
Kunish.
And Senator Limmer, I think you've been very involved in the missing and murdered Indigenous women, and you understand the levels of crimes and violence and things like that within that affect our tribal communities. I also served on the ORIC board where we were looking at the opioid overdose issue. And one thing that we know and that I've learned and has been enforced for me is that when we have culturally specific or culturally intended practices to address some of these issues, I've seen more and more success. I can tell you a number of folks that I know that have gone through addiction programs that were not culturally Native-centered, and the propensity to revert to those addiction issues continued. But then once there were, a really successful culturally specific addiction program, I know tons of people that because of that, they have been able to reduce that addiction or have been able to live a very different lifestyle because of that cultural connection. And I think this is another one of those examples that could be quite successful. And I know when I was learning about this myself, and I just pulled it up on my phone, that there are other programs throughout the United States, and there actually is the Tribal Issues Committee. I'm trying to look here. American Probation, American Probation and Parole Association. So there are other national programs or organizations that are also addressing it in this way.
Any further discussion? All right, seeing none, Senate File 1661 is going to be laid over for possible inclusion in our budget bill.
Thank you so much.
Thank you for spending part of your day with us here in Judiciary. Members, we're taking up Senate File 839, Public Safety Innovation Board. Senator Oumou Verbeten is the chief author of this bill. This is the first committee stop for this bill. There is an A1 authors. Oh, wait. Jump around here. Yes, there is an A1 authors amendment, which is a delete everything amendment. Members, Senator Oumou Verbeten moves adoption of the A1. What? Senator Oumou Verbeten, do you have an amendment to the A1 amendment before we do this?
I do, Mr. Chair.
Go ahead.
I'll need to delete Article 2.
Members, this is an author's amendment, so Senator Oumou Verbeten moves the A1 amendment without Article 2. All those in favor say aye.
Aye.
Opposed? Motion prevails. The amendment is adopted. Senator Oumou Verbeten, to your bill.
Thank you, Mr. Chair. The Public Safety Innovation Board bill is a bill that represents the work of a lot of folks to try to come up with innovative ways to promote public safety in our state. And it outlines the creation of a Public Safety Innovation Board within the Department of Public Safety's Office of Justice Programs. The board would consist of 3 academics, 5 governor appointees, 4 members appointed by the community-specific boards, 3 law enforcement representatives. Folks would serve 3-year terms and elect a board chair, and they'd be tasked with monitoring trends and research on crime and submitting a report to the legislature. It also appropriates funds to the Office of Justice Programs to work on their grant procedures and to hire additional staff to provide that training and assistance to grantees. There's also increased funding for the Minnesota Statistical Analysis Center. And what this delete all amendment did was actually just remove a lot of unnecessary things in this bill. Article 2 included several provisions around body cameras that we've already heard in this committee and have been laid over. So we're just sort of redundant in this bill. It also removed all of the grants, specific grants that were laid out that are included in a different Senate file. So this is really the heart of the bill, which is the creation of the Public Safety Innovation Board that is remaining. The remaining article, which is listed as Article 3 in your delete all amendment, regards some provisions for law enforcement policy. So permits the post board to order law enforcement agencies to conduct an inquiry into a written statement or complaint that alleges a violation of a statute or rule that board is empowered to enforce. And it does direct posts to adopt rules under Chapter 14 that permit posts to take action on a licensee for a violation of a standard of conduct, whether or not criminal charges have been filed and in accordance with the standards and processes for the boards. There is as well some language around civilian oversight councils and empowering local governments to make decisions on what they would empower those civilian oversight councils to do. There is an appropriation for the Philando Castile Memorial Training Fund, which will ensure that law enforcement has funds for training on things like crisis response, conflict management, cultural diversity. There's some changes that are in that funding just to make sure that the training goes towards what the legislature intended that training to be used for. I will just add that there are some pieces in the Public Safety Innovation Board right now that I've been in conversation with the Office of Justice Programs about to address some of their concerns, some potential changes to the membership, and just really clarifying what is the role of the board versus staff. I want to ensure, especially that when we're looking at grant making, that we ensure those responsibilities are given to our staff rather than a board that will meet regularly. I've also have been working with our House author, Cedric Frazier, on addressing some of the other concerns that law enforcement has with regards to the policy in Article 3, and ensuring that there's, adequate funding with the Philando Castile Memorial Training Fund. But I think this is a really important step in bringing together experts and community members to the conversation around public safety, really leading with community first to ensure that everyone feels safe in our state. So with that, I would love to hear, to have discussion with the committee and know that these conversations are ongoing. So your feedback's really important to me to see what concerns, what suggestions you have as we work to create this board.
Senator Oumou Verbeten, are there any testifiers that are presenting in connection with this bill that you're aware of?
No, Mr. Chair.
I don't see anyone in the room jumping up to come forward to offer their thoughts on this either. I do have a question about Article 3, Section 4 on the Civilian Review, or Civilian Oversight Council. I don't know if this is a question for you, Senator, or for our council, SEL. Is this authority that currently does not exist? Municipalities or local units of government do not have the authority to establish a civilian oversight council on their own?
Mr.
Is this
Chair.
a distinction between statutory and charter cities, for example? Senator Oumou Verbeten.
Thank you, Mr. Chair. I think it would be helpful for council to weigh in, but my understanding is that we did have similar provisions laid out in statute, and they were removed, and so this is an attempt to restore them with this bill. That was before my time.
Any help from council on this question? Mr. Backus.
Mr. Chair, members, I haven't reviewed that beforehand, but I mean, certainly that's my recollection as well, that there was more, I think, more robust authority for locals to do that, and that was essentially taken away 15, 20 years ago. That's my recollection, yes.
Any discussion among members of the committee? Senator Limmer.
Thank you, Mr. Chair. I know you asked for proponents to give testimony, but in our packets, we have a letter from the Minnesota Chiefs of Police and the Minnesota Sheriff's Association. My concern is whether this letter was dated yesterday. I don't know if their concerns were addressed in the delete everything amendment or not. I see a few of those folks in the room, and I was wondering if they could make comment.
Mr. Freeman.
Chair Latz, members of the committee, Tom Freeman, work at Fakery Drinker and represent the Chiefs of Police Association. Senator Limmer, to your question, I believe if I understood the oral amendment correctly, I was looking on my phone back there, I think some of the body camera concerns were addressed. Obviously, as Senator Oumou Verbeten has indicated, there have been other hearings on those types of proposals, so that's still obviously before the committee, and I think our position would be the same in a future bill. I think the other concerns related to the Civilian Review Board still remain and will remain going forward.
Thank you.
Any further discussion?
I ask for a roll call, Mr. Chair.
Senator Limmer, the plan is, because there's a fiscal note attached to this, the plan would be to lay it over for possible inclusion in the budget bill. Senator Oumou Verbeten, we're discussing whether the bill needs to go to state and local because it does create a board. Do you have any insight into that question?
Yes, Mr. Chair. I did reach out to Chair Murphy. I haven't received a response yet, but it is my understanding that it's my hope that they would not need to see the bill as we're laying it over here. Most of this will be under well, the entire board will be under the Department of Public Safety. I do understand that typically those things are sent to state and local government and veterans, but as we sort of made those decisions earlier today with similar bills, I'm hoping to, if we make any of those changes, do that in committee.
Well, Senator Oumou Verbeten, there was one earlier bill, but it was almost identical to a bill that had in fact been heard already by state and local government. This bill before us also has a rules provision, rulemaking provision under Chapter 14. So I don't know how we avoid the jurisdiction of state and local on this bill. We could dual track it like we had thought we might be doing with the earlier bill today. So we could send it to them. They could give it some consideration. They probably wouldn't be able to hear it before our budgets are due. But that might be the only, I'm not comfortable just hanging on to it when there's a couple of provisions that are clearly within their jurisdiction. So I think the appropriate motion now then would be for Senate File 839A. I'm going to recommend that the motion be that Senate File 839 as amended be moved without recommendation and re-referred to the Senate Committee on State and Local Government. Senator Oumou Verbeten, it's your bill, so you get to decide the form of the motion. You're on the committee, you can make the motion.
Yeah, thank you, Mr. Chair. That's fine. I can move that motion. Before that, I just wanted to note one other piece of the bill, which was funding for the post board for some of the investigation and compliance that was laid out. And that funding is also a recommendation from a report from the Office of Administrative Hearings. So that's what informs that appropriation and that recommendation.
Okay.
I will make that motion.
So Senator Oumou Verbeten moves that Senate File 839 as amended pass without recommendation and be re-referred to the State and Local Government Committee. There's been a roll call requested. I will note that if it gets passed out of state and local, it would, from there, well, there's an appropriation component to this, so it would have to come back here because we would carry the appropriation on this bill either way, which we'll have to decide what to do with before our budget is released.
Mr. Chair, I'll lift the roll call motion.
Senator Limmer withdraws his request for a roll call. All those in favor of the motion say aye.
Aye.
Opposed? No. Motion prevails. Senator Limmer.
Mr. Chair, as I sit here and go through this volume of legislation, I can't help but notice so many delete everything versions of almost every single bill. And when that's compounded with the fact that some of these were printed and made to our availability less than 24 hours ago, this is really quite the process that I have not quite experienced in recent times. The increase in the piece of legislation, the very last day of a deadline, and with the number of delete everything amendments, I don't think it's doing a whole lot for transparency in this process. A lot of our citizens don't even know there's delete everything amendments. Some of them don't even know there were hearings. I don't know how they would, if you're not living on a computer, I don't know how you would get to the point of being able to participate in a committee hearing. And I noticed also in the last agenda list that we have, we don't have any testifiers listed anywhere. So I think that might be emphasizing my point that general public and even those who are proponents or opponents are incapable of either understanding what we're doing here today or, for that matter, having the time to react so quickly to the process of all these delete everything amendments.
Senator Limmer, as you know, there is no 24-hour rule for amendments. And we simply post and distribute amendments when we receive them for the bills that are coming before us on the agenda. So I understand it is a challenge. We are not rushing anything through in terms of our deliberations here today, so we're trying to give as much space as possible for the members to review the bills that are before us and to ask questions, and as you have done, to ask if there are any members of the audience that want to contribute to the discussion to come forward like you did on the last bill. So I acknowledge there's a lot of work here today, so we'll it's just the best that we can do, and if a member's not comfortable moving a bill forward with whatever level of knowledge they have the right to vote against the bill. Senator Pappas.
Thank you, Mr. Chairman. I didn't mean to interrupt you. Sometimes I've been a little late in getting my comments in, and then we passed the bill. Mr. Chairman, I know that I feel like these bills are going through so many committees. They're getting really a very thorough review by staff and by members, and that sometimes I find it just easier to see a delete all amendment rather than having to engross it myself. So I don't think a delete all amendment at all means that it's a total rewrite of the bill. I think it's just kind of combining the amendments that were made in the last committee and then putting it into a format that's a little bit easier for us to read and understand rather than having, like I said, to engross it ourselves. So I wanted to just assure Senator Limmer that I think that's the case here.
Mr. Chair.
Senator Oumou Verbeten.
Thank you. Yes, and certainly with the case of my last bill, there were a number of sections in there that we've already heard. And so really the delete all is to simplify and ensure that we could focus the conversation on the creation of the board, which was the first 2 pages of the bill. Removing all that entire article, all of the grants that would be found in another file. So I think, delete alls can be different, but in that case it was actually just removing it and simplifying and giving us less pages to go through.
Mr. Chair.
Senator Kroon.
Just note for the record that I'm looking at the public website right now, and there are at least 5 bills that I'm counting where the delete everything amendment or substantial amendments are still to this minute that we've already heard are not posted on the public website. On 5 bills that we've already heard.
So, Senator Kroon, the obligation of the committee administration is to get the amendments into the hands of the committee members themselves. Unfortunately, the technology that we're working with here in the Senate is a bit slow and cumbersome, hasn't been updated in, 13 years or something like that. I'm not sure if that's right, in a long time. One thing we might consider doing is increasing the budget of the Senate for information technology purposes. But these committee hearings are open. The agenda is posted as far in advance as possible. The committee amendments are available in the room here, and the room is open to the public for participation and review. And I would also note it's not unusual for us to be confronted with amendments here from members of the committee that have not been made available to the committee members or to the public ahead of time at all. They are presented to us at the moment that the senator chooses to offer it, even when they have been printed earlier in the day or the day before, but they are sprung on all of us committee members as well. So this appears to be a bipartisan issue, I would respectfully suggest. And if we can all live by the same rule, that'd be better. We do not have an amendment posting rule in the Senate like they do in the House. And that's certainly an option that we could do, and then all of us would be well informed before the committee gavels in of what is potentially being offered by members of the minority in this committee as well as members of the majority as they are bringing bills through. I have not had an opportunity to go back and take a look at what amendments were offered by chief authors from both parties as we've come along this process either. Senator Westland.
Just very briefly, Mr. Chair, and I would simply like to say that all of our staff, including nonpartisan staff and partisan staff, are moving things through. We've got deadlines. Things are moving from committee to committee. And so I don't want it to be lost on anyone regarding the number of hours they are putting in, trying to get us things as quickly as possible. They are doing yeoman's work, and so I just want to say thank you to our staff. Again, both nonpartisan and partisan staff, committee assistants and so on are really working hard to make sure we get the information.
Mr. Chairman,
Senator Limmer.
I don't want to belabor this too much, but a comment was made that some of these bills have gone through a number of different committees, and the vetting is proper and secure in some people's minds, but I don't accept that. I am not participating in other committees as they give hearings. I don't know what they're doing or analyzing. My job rests right here, and I need time and proper energy to dissect bills as they come before me. So our job is very narrow. But I might remind everyone that the purpose of a committee is to hear from the public. The committee process in the American form of government is where the public gets up in front of a testifier table and tells us if we are going in the right direction or if we're not. But if we overload the system with so many bills and so many fast changes that are represented in a delete everything amendment, the public doesn't know. And that's what I'm trying to emphasize. It's bad enough for us to try and digest all of this, but it's nearly impossible for the public to know what we're doing right now.
Well, Senator Limmer, one of the purposes of the committee is to take public input. And if they follow the committee and the agenda posting, if they're on the email listserv, which everyone in the public has a right to sign up for, so they get notices of every committee hearing and what the agenda is, they have a right to come here and to participate and indicate if they'd like to testify. I haven't seen anyone attempt to approach or give any indication that they wanted to testify in any of the bills that there being concerns raised about here. We're doing the best that we can under the circumstances on deadline day. We're hearing a lot of bills, which is part of what also I think the legislature is intended to do, not just to receive and put bills into a catacomb, but rather give them an opportunity for the light of day and to be considered by this committee. I think I'm going to leave that line of thought end right there, Senator Limmer. I am going to make a note as to why I suggested that Senate File 839 be passed without recommendation, which is not always the case here in this committee. But there is a provision in there which is a very substantial change in existing law with regard to civilian review of police conduct or law enforcement agencies. We did not have a discussion about that, to my knowledge, in any other bill before this committee this session, at least. It would change substantially the process by which law enforcement complaints, investigation, and discipline is conducted in the state of Minnesota, should a local government choose to establish such a committee. And it would, rather than have a prohibition in statute over this, it would be permissive for local governments to do this. So I have some hesitation, at least, would like to hear a robust discussion on that. That is not going to happen today. But I wanted the bill to be able to move on to the appropriate committee for some portions of the bill that the chief author emphasized as the core features of the bill relating to the Public Safety Innovation Board and the grant making. So that's why I supported moving the bill along today, and it's available for dual tracking in the budget. But I will just make a public statement so that I'm not accused of hiding anything here. That provision is one that I'm not comfortable with at this time. So it won't be any surprise to folks, what approach I take to that as we move forward. So I think it's certainly a topic worthy of substantial discussion. I have no quarrels with that. There didn't seem to be an appetite for that among members of the public or stakeholders here today as we looked around the room to see what concerns were raised. And Senator Limmer specifically identified the Law Enforcement Association's letter, which raised that as a concern. And they did come forward, but no one else seemed to have any further engagement on that. So I just wanted to make that matter of public record so no one gets surprised on that. In any case, Senate File 839 is behind us at this point for this committee's agenda. We're going to move on now. Senator Morrison, I believe, was here. Senator Morrison is online. Okay. We're going to take up, looks like we have the House file in front of us, members. House File 366, provisions applying to persons receiving or providing reproductive health care relating to release of records and other matters. So that, members, is being distributed to the committee members at this time. Senator Morrison is joining us virtually. So members and members of the public, when we get a House file, it's because the House has taken action as a full body and has passed the bill and transmitted it to the Senate, where it's automatically referred to the Committee of Jurisdiction in the Senate. And it basically displaces the Senate file that has been sent to us. So what we have before us now is House File 366. The Senate author of the companion bill is Senator Morrison. Senator, welcome to the committee.
Thank you, Mr. Chair.
And tell us about your bill.
All right. Mr. Chair, members, I have House File 366 today, otherwise called the Reproductive Freedom Defense Act, which protects Minnesota healthcare providers, Minnesota citizens, and patients from around the country against legal attacks and criminal penalties imposed by anti-abortion extremists in other states. States including Texas, Georgia, Arkansas, Mississippi, Missouri, and Alabama have passed or introduced laws that criminalize abortion with penalties that can include fines, imprisonment, and revocation of medical licenses for the abortion provider. These laws do not just reflect different ideologies. They radically interfere with the standard of care and the practice of medicine. And without our action, they will reach within our borders, following patients and preventing them from receiving life-saving medical care and penalizing the Minnesota professionals that continue to legally provide it. Just a couple of weeks ago, 5 Texas women were joined by 2 doctors to file suit for the way women were denied necessary and potentially life-saving obstetrical care because medical professionals throughout the state fear liability under Texas abortion bans. One of the women, a 28-year-old from Dallas, learned that her fetus would not develop a skull and had a severely underdeveloped brain. She risked hemorrhage, not to mention grave physical and emotional burden, if she continued the doomed pregnancy, but was only able to receive an abortion because she could travel to Washington, where it was legal to receive the recommended medical care for her diagnosis. A mother in Louisiana suffered through concerning symptoms during her first trimester of a wanted pregnancy because due to Louisiana's anti-abortion restrictions, doctors would not see her until she was 12 weeks pregnant for fear they would be implicated in the gray area between miscarriage and abortion. She did miscarry painfully and with potential complications after several weeks, and doctors would not confirm, much less appropriately manage her miscarriage. She did not travel for care. Her husband at times feared for her life, and she said she felt total abandonment and just completely being written off by physicians that we saw. She told a reporter, "This experience has made me see how Black women die. Like, this is how Black women are dying," she said. So what should happen when patients like this seek care in Minnesota? Providers here are seeing more patients from farther away across the United States than ever before. Patients from Texas, Louisiana, South Dakota, Wisconsin, and more who want an abortion, and patients who need miscarriage management or whose lives are at risk because of their home state laws are seeking care here in Minnesota. They deserve access to that care, and our medical providers should not have to risk upending their lives and their livelihoods to provide it. Seeing these laws not only introduced and passed in other states, but so far allowed to stand in the courts is shocking, and we can't sit by. While those outrageous new laws are being implemented and challenged, the Reproductive Freedom Defense Act would protect providers and patients and prevent Minnesota's courts and institutions from being hijacked and weaponized in service of the anti-abortion agenda of people outside Minnesota. Here are 3 ways the bill would protect those who provide and seek care here. Number 1, patients deserve privacy, and no one should have their medical history used against them in a lawsuit or legal enforcement. This bill ensures that the law governing the release of health records excludes out-of-state subpoenas and court orders for records related to abortion, contraception, and other reproductive health care. This ensures that disclosure laws cannot be weaponized for other states' prosecution of healthcare providers under Minnesota law. Number 2, patients deserve community support from their network when seeking care. This bill protects providers and patients and friends and family and others who assist them against subpoenas, actions, and judgments for providing or accessing reproductive health care that is legal here in Minnesota. Just last week, a Texas man filed a lawsuit against 3 friends of his ex-wife after she allegedly ended her pregnancy, claiming wrongful death and seeking more than $1 million in damages. Next time, the friends could be any one of our constituents supporting a loved one in need, and this bill would protect them and allow them to countersue in Minnesota to recover any costs affiliated with that case. Number 3, it's the job of healthcare providers to care for their patients. We're not lawyers. We know and follow the law and regulations in our state, but can't be expected to understand the radical restrictions that other states are passing. We certainly cannot be expected to import those restrictions here. This bill ensures that out-of-state conviction for the routine practice of reproductive health care that is legal in Minnesota is not cause for discipline by medical and nursing boards or for failing a background check. And under this bill, Minnesota will not help arrest or extradite Minnesota providers and others charged with providing or helping patients access legal, appropriate medical care. With nearly 1 in 3 American women between the ages of 15 and 44 living in a state that bans abortion, it's crucial to act now to protect patients and providers in Minnesota and those coming from out of state seeking care. And with that, Mr. Chair, I believe I do have one testifier who I think is online.
Senator Morrison, we do not have the name of your testifier with us, so.
I see my testifier on the Zoom screen. It's Christy Hall of Gender Justice.
All right. Ms. Hall, go ahead and introduce yourself and present your testimony, please.
Yes, good afternoon, Chair, members of the committee. My name is Christy Hall, and I'm a senior staff attorney at Gender Justice, legal policy and policy advocacy nonprofit that's dedicated to advancing gender equity through the law. And I'm here today to speak in support of HF 366, the Reproductive Freedom Defense Act. We're deeply concerned about the impacts of the U.S. Supreme Court's decision to overturn Roe versus Wade and the attack on abortion rights, individual liberties, and privacy around the country. Many of these laws seek not only to ban abortion in their own states, but also to reach across state lines, preventing people from traveling elsewhere to get the care that they can't get at home, and punishing those who provide abortion care and those who help people get it. The goal of these laws often is to scare providers and patients, and ultimately to stop all abortions wherever they occur. And our state has a responsibility to protect Minnesotans from the extreme abortion laws of other states and protect all who travel here to seek care. The Reproductive Freedom Defense Act creates strong protections for Minnesota's own healthcare providers and others who help people get reproductive health care against attacks and criminal penalties imposed by other states. It's the job of healthcare providers to care for their patients. They're not lawyers. They know and follow the law and regulations in our state, but they can't be expected to understand the radical and extreme legislation that other states are passing. So they need to be able to provide care that's legal in our state to patients without fear of repercussions from other states' laws. And so to protect providers and others helping people receive abortion care, HF 366 ensures that having been disciplined or convicted in another state for providing reproductive health care that is lawful in Minnesota is not cause for discipline or withholding of licensure by Minnesota's Board of Medical Practice. It protects Minnesotans from laws encouraging citizens to sue individuals for providing or helping someone obtain abortion care that's legal in Minnesota. And it protects individuals from being delivered to another state under an extradition order for providing an abortion, and protects individuals from being arrested in Minnesota under out-of-state laws related to abortion care. The Reproductive Freedom Defense Act protects our rights, privacy, and dignity. There's strong support for these laws among Minnesota voters. In fact, 3/4 of Minnesota voters want to see abortion providers protected against legal action against them by other states that have banned abortion. And 74% support protections for people traveling from out of state to get abortion care in Minnesota. So it's crucial to act now to protect patients and providers in Minnesota and those coming to Minnesota seeking care from the attacks enabled by the Supreme Court's decision. I urge you to pass this legislation, and I'm available to answer questions. Thank you.
Thank you, Ms. Hall. Senator Morrison, do you have any other testifiers?
I don't believe so, Mr. Chair.
Are there any comments, or is there any discussion from members of the committee? I am not seeing any at this time. Members, this bill goes back to the Senate floor from here, it's my understanding. So Senator Pappas moves. Go ahead.
Thank you,
Senator
Mr. Chairman. I'd move that House File 366 be recommended to pass and sent to the Senate floor.
Senator Pappas moves that House File 366 be recommended to pass and be sent to the Senate floor. All those in favor say aye. Aye. Opposed? No. Motion prevails. All right, Senator Morrison, you stick around. We got another bill of yours here.
Thank you, Mr. Chair.
Senate File 1526. I understand we do have some testifiers, but before we get there, Senator Morrison, let's see what we have. There are amendments in our packet, and this, we are not the Committee of Original Jurisdiction, and It looks like not all of the provisions are necessarily within the jurisdiction of the Judiciary Committee, so I'm going to ask counsel to identify for us which provisions we should be focusing on. I see at least one liability provision in here. Ms. Primo.
Mr. Chair and members, yes, it's the liability provisions at line 510 to 518. And I'm looking at the A10 amendment. It looks like it's making some property county recording amendments to page 5, but lines, I think, 4 through 7. Those, would be within the jurisdiction. I'm not sure about the A9. I haven't looked at that one, but those don't look like they're amending judiciary provisions. I'm not familiar with that amendment.
All right, so Senator Morrison, why don't you describe the bill to us generally and then focus in, if you would, on the liability provision that's within our jurisdiction. We'll start there.
Okay, thank you, Mr. Chair. Mr. Chair, members, Senate File 1526 is a bill that takes steps to address the growing problem of chronic wasting disease in Minnesota. Without going too deeply into it, chronic wasting disease is a neurological disease that affects the cervid family and has a 100% fatality rate. Controlling the spread of chronic wasting disease is our current challenge to avoid decimating our wild deer herd while protecting farm cervids, and this bill attempts to strengthen and provide some clarity to our efforts. So the two sections, I guess I would say too, Mr. Chair and members, a lot of work has been done with many stakeholders to craft a Senate bill that's acceptable to most parties. And that A9 amendment is the one that is probably not in the jurisdiction of the committee. If you're willing to take it, I'd be grateful. If not, that can be done at the next stop. The A10 amendment, I believe, as council indicated, is in your jurisdiction. It was requested by the State Bar Association and the Minnesota County Recorders Association for technical corrections. But the two sections of the bill under your jurisdiction are Section 1 of the bill allows a hunter to kill and possess an escaped farmed cervidae without being liable to the owner. It also requires that escaped cervidae that is killed be tested for chronic wasting disease, and it specifies that the owner is responsible for paying for the proper disposal of a positive escaped cervid and for paying any cost associated with that escaped cervid. Section 7 of the bill makes a herd owner liable to anyone injured by the owner's sale or unlawful disposal of a farmed cervid infected with or exposed to chronic wasting disease. It also makes the herd owner liable for the costs associated with unlawful disposal of a cervid infected with or exposed to chronic wasting disease. So those are the two sections under your committee's jurisdiction. And Mr. Chair, Assistant Commissioner Bob Meyer just joined me on the Zoom screen.
Good afternoon, Mr. Chairman.
Why don't we start with Assistant Commissioner Meyer. Go ahead, sir.
Mr. Chairman, members, for the record, Bob Meyer, Assistant Commissioner, Department of Natural Resources. We have been working with Senator Morrison and the Environment Committee on this issue. I'm here more as a reference for technical questions, but in support of the provisions that Senator Morrison just reviewed as well.
Thank you, Commissioner Meyer. We also have Tim Spreck from the Minnesota Deer Farmers. Is Mr. Spreck here? Mr. Spreck is coming forward. Why don't you go ahead and have a seat, introduce yourself, and provide us with your testimony. And don't forget to sign in. There should be a sheet there.
Good afternoon, Mr. Chair and members. You really got me on my toes here trying to incorporate the amendments into my discussion. I think myself and...
I don't want to, sorry to interrupt you, but
sure.
The A9 amendment does not really seem to be a Judiciary Committee amendment. This bill is going to go back to the Agriculture Committee. And so I think we're just not going to take any action on the A9 amendment.
But you've taken the A10, correct?
We will take the A10,
okay.
So if you have any comment about that, we'd love to receive it. Thank you.
Mr. Chair and members, for the record, Tim Spreck with the Minnesota Deer Farmers Association. I'm going to tag team a little bit with Mr. Quillis from the Minnesota Elk Breeders so that we don't duplicate testimony. I know everybody would like to get out of here if possible. I'm going to look at Section 6, Subdivision 11D7, line 5.4 to 5.7. Under this provision, the owner must record notice with the county registrar or recorder or register of titles. Actually, Mr. Chair, this is not needed. So in real estate law, and most of you on this committee who are lawyers will understand this, current law requires disclosure of any material facts at the time the property is marketed to a potential buyer. Registration with the county recorder or registrar creates a permanent encumbrance on the property and actually clouds the title. This doesn't allow any way to get rid of this easily. It's when it's on, it's on. It doesn't take into account what could happen in the future when we find new methods for disinfection or pre-on viability on the property. So currently, the current system is what actually works. And so we find this to be redundant and not necessary, and it actually creates a problem for the owner of the property moving forward. And as the amendment was incorporated, this makes it slightly better because it does give it a 10-year sunset, but it also brings up additional problems and questions that we have, such as how would removal of this actually be recorded? Is there a legal proceeding that would need to be followed? And other questions that we're struggling with here as we read the amendment. So, Mr. Chair, those are my comments. I'm happy to answer any questions or to have additional discussion.
I do have a question for you, Mr. Spreck. If we were to, if paragraph 7 were to remain in the bill, do you believe that the A10 amendment provides additional value and clarity to it?
It does, but Mr. Chair, the additional questions we have about how that cloud on the title is removed after 10 years are what we're concerned about. Okay. It doesn't seem that there's any mechanism within the A10 amendment to take care of that. Also, additionally, one comment on line 5.1 to 5.3, this provides additional disclosure at the time of sale in conjunction with what is already currently done in law and practice. And, you know, we think that what is taking place on line 5.1 to 5.3 actually strengthens the current disclosure law, and I don't think we would have a concern with that. But what's happening under Section 7 is very concerning.
Thank you, Mr. Spreck. I see Mr. Quillis has joined us at the testifier table. Would you like to offer some testimony as well, sir?
Mr. Chairman, members of the committee, my name is Tony Quillis, and I'm representing the Minnesota Elk Breeders Association. And Mr. Chairman, the concerns, I want to echo the concerns that Mr. Spreck has, but also under Section 7, the liability section, Mr. Chairman, where it talks about a herd owner is liable for civil action to a person injured by the sale or unlawful disposal. Unlawful disposal is understandable, and those persons should face civil action if you're unlawfully disposing of farm cervid infected with chronic wasting disease. But Mr. Chairman, the sale, the incubation period in elk for CWD is 3 years. And so for a sale, if an individual sells an elk, in this case, Mr. Chairman, through no fault of that person, individual, the elk might become infected later down the line through no fault of their own, through somebody that didn't follow correct protocols, somebody that didn't follow best management practices, and they would be held liable. And so the question we had was after farm cervid on lines 5.13, would it be safer to say known to be infected? Because through no fault of the owner upon that sale, that elk might not be infected or isn't infected, Mr. Chairman, and then through no fault of their own, 2 to 3 years later could become infected. So that was the concern there was upon the sale, infected with. It should, we're trying to wordsmith known to be infected, reason to believe was infected. So that was just the concerns, Mr. Chairman.
Thank you, Mr. Quillis. I don't have any other indication of testifiers interested in testifying at this time in the bill. Is there anyone else in the room? I don't see any. Senator Morrison, what is your reaction to the testimony that we just heard?
Mr. Chair and members, I guess my reaction is the intent of this bill is to stop the spread of chronic wasting disease. And there are different ways that we have to do that. And one of them is making sure that if cervids are being transferred from a farmed deer setting, they should probably be very certain that they are negative for CWD before that happens. And that's what this section does. I don't know if Assistant Commissioner Meyer has anything to add to that.
Assistant Commissioner Meyer.
Mr. Chairman, members, the other piece that is there is the actions. I don't have anything to add to that piece, Mr. Chairman, but the other piece about liability for actions, we are working with the Board of Animal Health on a case that in 2019, a deer farmer did dispose illegally of carcasses that were infected with CWD that did cause the state to spend $200,000 to protect that area. That person is, that issue is in negotiations with the Board of Animal Health and the Attorney General at this time. So this would clarify that is a response that would be needed in those situations.
Assistant Commissioner Meyer, what are your thoughts on the points that were raised by the testifiers about clouding title?
Mr. Chairman, members, that has been a point of discussion we've had. I think the amendment does provide a little relief, but the concern is these areas, these pens, or sometimes they're larger confinement areas, once they are infected with chronic wasting disease or these deformed prions, they've been known to last. Now there's research that says they're there for 15 years or more, which available to infect additional animals. So trying to however we can make sure that a potential buyer is not getting into some kind of liability issue with an infected land is our main concern. So however we can do that most effectively is what we're trying to do with that language, or the author is trying to do for that language, Mr. Chair.
So Assistant Commissioner Meyer, paragraph 6, as a testifier indicated, appears to require a disclosure as part of an agreement or prior to signing an agreement to sell or transfer the property. Is paragraph 7 then an additional method by which that disclosure is intended to be made known to anyone considering purchasing the property by recording that information with the county recorder? Is that how this all fits together?
Mr. Chairman, I believe that's the intent of the legislation, but that is out of the realm and jurisdiction of the department.
And then what is the reaction, Assistant Commissioner Meyer, to the concern about that was raised by Mr. Quillis relating to the language of liability, adding known or reason to know or reasonably known before infected on line 5.13?
Mr. Chairman, members, I think that there is a question there that is worth discussing as this disease is relatively unique. But I would defer to the author. This bill is still being worked upon, and I think that is something, the considerations we could take into the next stop as we work, if we get through this committee with that language, Mr. Chair.
Senator Morrison, what are your thoughts on that proposal by Mr. Quillis?
Mr. Chair and members, I guess I would echo Assistant Commissioner Meyer's comments that, we've done a lot of work on this bill and we continue to. This is a very challenging subject. But it's one that we have to get right, because if chronic wasting disease continues to spread, there are concerns that it will develop the potential to jump species. And if it came to the point where it infected agricultural animals or, God forbid, human beings, it would be a whole new ballgame. So aside from our immediate concerns about protecting the wild deer herd, we have I think we have 500,000 deer hunters in the state of Minnesota. And if we lose all of our white-tailed deer, that goes away. That's a big part of our tradition and our heritage and our economy here in Minnesota. So we're working hard to get the language right. We're as you mentioned before, we're going to the Agriculture Committee next. So there's still time for us to work on language, and that amendment that I shared that I will bring to the Agriculture Committee is part of that work.
So Senator Morrison, the provision specifically here in front of the Judiciary Committee does relate to the liability. And so I'd prefer that we address that question within our jurisdiction and let the Agriculture Committee work on the policy side of it, or the other parts of it that are within their jurisdiction. I'm trying to think this through, and we're going to open it up for advice from council and consultation with members of the committee as well. But as the liability provision is written right now, it's a strict liability provision. So the claimant would still need to prove causation, that the injury was caused by the owner's sale, but they wouldn't have to prove any mens rea or intent component on the part of the seller, whereas the proposed language by Mr. Quillis would narrow that range of liability to known or reasonably known to be infected by. So I think maybe I'll ask Ms. Primo if she agrees with my analysis there. Maybe that sets the table for our conversation. We do have a real estate attorney present on the committee who might be able to give us some guidance on this. But Ms. Primo, any thoughts on that provision?
Mr. Chair and members, yes, that's how I read paragraph A. I think it's just a policy choice for the committee in terms of whether to add in some sort of knowing element to the statute, the bill.
Any discussion by members of the committee on this?
Mr. Chair.
Senator Kroon.
Thank you, Mr. Chair. Are we specifically limiting our comments to the liability issue or the cloud on title issue that was raised as well?
Council has, Senator Kroon, council has advised that the title issue is also something within our jurisdiction, so comments are welcome, Senator Kroon.
Yeah, and then, thank you, Mr. Chair. The A10 amendment does say that the notice expires and has no effect 10 years after the date of detection stated in the notice, so I suppose with that language, there would be an accompanying title standard created that a title examiner could ignore that notice based on the face of the document after 10 years. It does direct the registrar on Torrance property to omit it after that. Of course, it's going to be there forever on abstract property. From a pure title standpoint, I think it can be ignored. But, it's on the real estate records and can't get rid of it once it's on there. But I'm not sure I see a specific marketability of title issue given the A10 amendment. But there could be other ways to accomplish this probably other than doing this. But in terms of just what I'm seeing here, I understand the concerns with it being on the real estate record, and if it's only supposed to be for 10 years, I mean, you'll be able to find this 100 years from now when you do your real estate records. But I don't think it necessarily affects the marketability of title, although it could affect the marketability of the land itself.
Mr. Chair, if I may.
Mr. Spreck.
Our concern here is current law and practice requires disclosure of any material fact in any potential real estate transaction. That, with the items currently listed in the bill on line 5.1 to 5.3, I think more than sufficiently accomplish the author's intent without clouding the title or placing an encumbrance. And whether or not there's a way to get around it, I don't think should be a consideration to this committee, because it really does place, even though it's only for 10 years, it does place that cloud on the title. And, you know, like I said, even though there might be a way to get around it, it's gonna give people pause. I think the disclosure in current practice and law plus the additional disclosure should be more than sufficient to get the author's intent.
Mr. Spreck, I'm not all that familiar with land transactions of this nature, but I am a little bit skeptical about trusting sellers to make required disclosures in the course of those transactions.
Mr. Chair?
Mr. Spreck.
I think this additional piece that we're adding here, 5.1 to 5.3, makes it incumbent upon the seller to do that disclosure. I don't know what the penalty phase would be for not doing it, but, you know, we are placing it into statute.
Senator Morrison, what's your thought about whether or not paragraph 6 is sufficient, or whether paragraph 7 is important enough to keep in there? Senator Morrison?
Mr. Chair, thank you. This amendment was added in the other body's version of this bill. And again, you know, the idea of all of this is to try to prevent the spread of CWD and to alert people to its whereabouts. And so I agree that 5.12 through 5.15 is strong language. And if the committee deems that that's adequate, this can be discussed in conference committee, I suppose. Again, I just reiterate, the intent is to decrease the transmission of CWD. And as Mr. Meyer noted, there's good science that has shown that these prions exist in soil for at least 15 years. So animals can be infected just from being on the soil. So this is a tricky disease that we have to be very planful and careful with.
Well, I guess for what it's worth, I'm more comfortable having a belt and suspenders approach here. So I'd personally be inclined to leave paragraph 7 in there. But I would also take into consideration what Mr. Quillis has said about the liability provision, although I think I'd suggest language on line 5.13 before the word infected, to the effect of knows or should have known. That way, there's still some, they can't simply claim ignorance as an excuse. So, Senator Morrison, what do you think about that as the chief author of the bill?
Mr. Chair, I don't think that that is unreasonable. I know that if I were purchasing a a deer from a deer farm, I think I'd want it to be tested before purchasing it. But I don't think that's unreasonable language. I would be open to that.
We're doing lawyerly things here. Scribing it, and so the Senate Council is going to read a proposed amendment for the chief author and the committee to consider. Ms. Primo.
Mr. Chair and members, line 5.13, before infected, insert, which the herd owner reasonably should have known was.
Knows or reasonably should have known?
Which the herd owner reasonably should have known was. Should I read the whole sentence? Or-
Yes. No, the only question is, do we put knows or knew or before the reasonably should have? Knows or reasonably should have known?
Okay, yes. Oh, knows.
While council is working on language, let's just see if there's any other discussion by members of the committee. Boy, the committee's not helping me stall right now.
Well, Mr. Chair, I can jump in.
Senator Kroon?
Thank you, Mr. Chair. I'm just, and forgive me if this has already been addressed, but how is the owner here supposed to know definitively that he or she is supposed to record this real estate document? Is there any sort of adjudication, or what is the process at the point where the property owner knows, okay, this real estate document needs to be recorded?
Well, I assume the owner is presumed to know the law.
Yeah.
Senator Kroon?
Thank you, Mr. Chair. But what triggers the knowledge that he's supposed to have to know that the law's been triggered? It's a test of some sort, I understand. Help me out here.
Senator Kroon, I think on line 4.20, the operative introductory line to the series of numbered paragraphs below it says the owner of a premises where chronic wasting disease is detected must. So when CWD is detected on the premises, I think that triggers the recording requirement in paragraph 7. That's the way I would read it.
Mr. Chair, but who's doing the detecting? And it's a passive verb tense there. I'm just trying to, that's kind of what I'm getting at.
Well, Assistant Commissioner Meyer, can you tell us how CWD is detected on premises?
Mr. Chairman, members, yes, and actually, I don't believe we have anybody from the Board of Animal Health here, but currently the DNR and Board of Animal Health have concurrent authority over the white-tailed deer farms, not the elk. The DNR doesn't have any authority over the elk. But upon positivity, is there somebody from the board there? Looks like.
We have another testifier appeared magically. Ma'am, go ahead and introduce yourself and your affiliation and help us out.
Thank you, Chair. For the record, my name is Michelle Medina, and I serve as the Director of Government Relations for the Minnesota Department of Agriculture. In that role, I also represent the Board of Animal Health. So
Could you lean forward a little bit into the mic?
Sorry about that. So in my role with the Department and the Board of Animal Health, for every farm survey, if one dies who is older than 12 months, they are tested for CWD. There's only accredited test currently with USDA is a post-mortem test. So every animal that dies over 12 months is tested. That is how we detect CWD on any farm survey farm.
And I would assume then that the owner of the farm is notified of the results of the testing.
Chair, yes.
I didn't catch your last name, I'm sorry.
Medina.
Medina?
Medina.
Medina.
Yes, so the farmer gets their test, so either it's detected or not detected. So they get all of their results for every animal. They must submit their animals for testing. It's not an option.
And would the agency then notify the farm owner of their obligations under the law with regard to reporting, including in documents of sale, recording with the county recorder, those kind of things?
I believe that'd be outside of our jurisdiction.
Okay.
But I think we could include that in information to the farmers.
Thank you. Any questions, Senator Kroon? Any follow-up on that?
Thank you, Mr. Chair. I think if a farmer is going to receive notification of a positive test, assuming that the notification would be in writing, I would imagine, and I'm assuming that written notification, they can add the new legal requirements that go along with that positive test, and I would hope that that Department of Agriculture would do that, or the DNR, or whoever you said provides that notice. As far as recording a document in the real estate records, if a farmer is going to go ahead and do that, they're obviously, as part of a sale, they're going to disclose it in that situation. I don't think it's really necessary, but I think maybe what you're getting at is for when that person goes to sell and that person, subsequent sales, the document recorded in the real estate would provide constructive notice to the new potential buyer. Is that the goal and the reason why the real estate document is part of this bill? Do I have that right?
Are you, Senator, was that to me? Well,
Mr. Sprague, go ahead.
thank you, Mr. Chair. I think that would be a question for the bill author. Our position is that we have already got safeguards in place and we don't need to cloud the title with additional pieces in statute.
Mr. Chair?
Senator Kroon.
Just to follow up on that, I understand, but what safeguards are in place on the subsequent sale, let's say 5-7 years down the road, by the buyer of the property who then turns around and wants to sell it to someone else? What safeguards are in place to ensure that buyer turned seller is going to disclose this?
So, Mr. Chair, if I could, when CWD is found on a farm, and there's been very few cases of this, there's been 13 cases over the last 20-plus years, so this is a very rare occurrence. So when that happens, a protocol kicks in. Board of Animal Health comes in, the USDA comes in, and at that point they have discussions about indemnity. USDA actually takes possession of the herd, negotiates with the farmer for an indemnity payout, disposes of the animals. They all have to be killed. None of them are going to survive. And at that point, additional protocols kick in. There has to be biohazard signage posted, fencing has to be maintained for a number of years, and additional. So my thinking is at that point, any potential buyer of that property within the time period of those protocols would already know that this is under quarantine because of the fencing and the biohazard signage. And then if that property is bought and sold again within that time period, which is what I think you're looking at, I would think it would also be incumbent on that secondary owner to disclose the material defects as well as the protocols that are in place at that point. So, you know, I'm going to go back to my original contention is that we do not need the registration with the county recorder. Sorry to bore you all with Deer Farm law.
Yeah, this is what we signed up for, Mr. Sprague. Senator Kroon, any follow-up on that?
No, Mr. Chair, I hope that cleared it up a little bit. I mean, it really comes down to, I guess, the disclosure and whether recording, to me, whether the recording in the real estate records is necessary or if it's like anything else and it's just incumbent on the owner or seller as a matter of law to disclose certain things to the buyer. I guess that's the decision for the committee.
And what is your recommendation, Senator Kroon, if you've reached one yet?
Thank you, Mr. Chair. I guess, I think it's pretty rare that you would incorporate disclosure requirements and require them to be put into real estate records. That could be done perhaps in some environmental law where there's been some pollution. That's not my area of practice, and I don't know how often that's done. But generally speaking, I think this would be pretty rare requirement. I mean, could it be workable in terms of title and stuff? Title lawyers are a pretty resilient bunch, and they can figure out how to make sure we can buy and sell real estate. But I would, like I said, yeah, I don't know if I would support the real estate document component to it, just because it seems a little unique and not something that is typically done in real estate records.
Senator Limmer, to that point.
I think the discussion is really about, and being a realtor myself for 43 years, we're required, and the property owners that are selling a property are required to disclose all material facts that may affect the value or the use of the property. I think the discussion here is that the material fact disclosure is something that would be a liability to a seller if they did not disclose it. And I know that real estate professionals that are in the business of selling really promote the idea of full disclosure when it comes to any type of material fact. This case is, even though it's unique, if it's true that it has to be fenced and it has to have signs hung on it, I would think that, and in addition, it would be on the purchase agreement of the documents that are used to transfer ownership. I would think that that would be adequate notice to any prospect that would be interested in buying that property. So I think you get into a lot of other difficulties when you start clouding a title. Then it takes on a different animal when it comes to the valuation of a property. People seem to react much more severely to a cloud on a title and it could affect the value of the overall farm in this case. So I'm kind of leaning toward the material fact angle on it.
Thank you, Mr. Chair.
Senator Kroon.
Thank you, Mr. Chair. I'm making an assumption here that the signage and the fencing, the biohazard stuff lasts for the same amount of time, that I believe 10 years. Am I right in that? That's the requirement?
Yes.
Mr. Spreck, could you
Yes.
speak up?
Yes, sorry.
Mr. Chair.
Senator Kroon.
Thank you, Mr. Chair. I would note I think that those visible signs on the property actually would constitute constructive notice to any real estate purchaser. So unless they actively went and took everything down against the law to erase any sign, which I imagine they'd be violating multiple laws at that point and digging themselves a pretty big hole to get out of. Absent that, those visible structures on the ground, I believe, would constitute constructive notice for real estate purposes as well.
Senator Kroon, how would you propose to proceed with regard to paragraph 7?
Thank you, Mr. Chair. Well, if the real estate requirements is going to be in there, then the A10 amendment's absolutely necessary to accompany it. That much I know for sure, so that there is an automatic expiration. Otherwise, you really do create a big title problem at that point. I think you could just strike paragraph 7, 5.4 to 5.7 in the original bill. Now then, all of a sudden, the amendments, there's some moot language there, and we would have some work. If the committee wanted to strike that requirement, then we would have to, I don't know if we've adopted the amendment yet, but we'd have to clean up the amendment if we did that.
Senator Kroon, it looks like the A10 amendment in its entirety addresses the language between line 5.4 and 5.7.
Mr. Chair, you're correct. So I guess that would just mean not adopting the A10 amendment if we took out line 5.4 to 5.7.
Senator Morrison, chief author of the bill, what do you think?
Mr. Chair and members, I would be uncomfortable deleting paragraph 7. I think that is important information for future buyers to be aware of. I don't know that there are, and perhaps Assistant Commissioner Meyer can help me here, but I don't know that there's signage up for that long required right now. So I'd be uncomfortable deleting paragraph 7.
Commissioner Meyer?
Mr. Chairman, members, I believe the language in the bill that's before you would require the fences to be up for 10 years, but I believe the signage, current board requirements, and maybe Ms. Medina can answer, I believe is only for 5 years for that signage and biohazard requirements.
Ms. Medina?
Chair, yes, that's correct, 5 years.
Members, we have some proposed language from Ms. Primo with regard to subdivision 11A liability. Ms. Primo?
Mr. Chair and members, page 5, line 13, before infected, insert, if the herd owner knew or reasonably should have known that the farm survey was.
Ms. Primo, could you read the sentence then as it would read with the amendment?
Mr. Chair and members, yes. So beginning at line 512, the sentence would read, a herd owner is liable in a civil action to a person injured by the owner's sale or unlawful disposal of farm survey if the herd owner knew or reasonably should have known that the farm survey was infected with or exposed to chronic wasting disease.
Senator Morrison, what are your thoughts on that?
Mr. Chair, members, I would consider that a friendly amendment, and I would accept it.
Senator Kroon moves the language as described by Ms. Primo.
So moved.
Any further discussion? All those in favor of the amendment signify by saying aye. Aye. Opposed? Motion prevails and the amendment is adopted. Now, members, the chief author wishes for us to adopt the A10 amendment. Clearly, it would be premised upon the idea of retaining paragraph 7 or lines 5.4 to 5.7 in the bill. Senator Oumou Verbeten, would you care to move the A10 amendment?
Yes, Mr. Chair, I'll move the A10 amendment.
Senator Oumou Verbeten moves adoption of the A10 amendment. Is there any further discussion on the A10 amendment?
Mr. Chair.
Senator Kroon.
Thank you, Mr. Chair. I think because we have not removed 5.4 to 5.7 in the underlying bill, I think the A10 amendment is necessary, so I'm going to be supporting it.
Seeing no further discussion, all those in favor of the A10 amendment, say aye. Aye. Opposed? Motion prevails. The amendment is adopted. Any further discussion on Senate File 1526 as amended? Not seeing any. Members, the proper motion then is that Senate File 1526 as amended be recommended to pass and be re-referred to the Senate Committee on Agriculture, Broadband, and Rural Development.
So moved, Mr. Chair.
Senator Oumou Verbeten makes the motion. All those in favor say aye. Aye. Opposed? Motion prevails. Thank you, Senator Morrison.
Mr. Chair and members, thank you for your thoughtful consideration. It's greatly appreciated.
Thank you for your participation, Mr. Spreck.
Thank you, Mr. Chair, members.
And Senator Morrison, that's all we have from you today. Have a good evening. Well, she's already gone. That was quick. Couldn't wait to get off the screen, could you? All right, members, we are going to take the Fair Repair Bill up next. Senator Kupik's bill. Members, as promised, we do have a number of items left on the agenda that we're not going to be able to get all of them in before a dinner break, although we can get our non-Judiciary Committee members out of here sooner. So what I propose to do, members, is we address Senator Kupik's bill, Senator Klein's bill, and Senator Wickland's bill, if we can get Senator Wickland free from her own committee obligation before we take a dinner break, and then we'll have a few left for committee members. But at least we won't have other senators waiting around for their bills to be heard until after a dinner break. As promised, I did indicate that I would purchase pizza for the committee if we have to work through dinner tonight. So I am willing to do that, and if the committee is interested in working through the next couple of bills, we can sort of aim for 7 o'clock dinner break. We'll order pizza from Mama's. Any thoughts? No objections to pizza from Mama's? All right, members, that's the plan then. We're going to aim for 7 o'clock pizza, so we'll have an incentive as well. All right, Senator Senator Kupek, if you wish, you are welcome to stick around for some pizza as well.
It's okay.
Senator Klein is welcome to join us for pizza if he wishes as well. Although he might not, as a medical doctor, he might not recommend it. All right, Senate File 1598, Senator Kupek, Digital Fair Repair Act. We have the bill in front of us. It comes from the Commerce Committee. There are no amendments in the packet, members. Let's just identify if there are any particular provisions we should pay attention to as within the jurisdiction of the committee. Senator Primo, or Ms. Primo, rather, can you tell us what we should be looking at for jurisdiction here? Or is it the whole bill?
Mr. Chair and members, there's an authorization for enforcement on page 5, the beginning, at the very top, subdivision 4. That's the reason it's before the committee.
All right, Senator Kupek, give us a brief description of the entire bill, and then if you have any specific comments on the enforcement, we'd love to hear your testimony on that as well.
Sure.
Senator Kupek.
Thank you, Mr. Chair, members of the committee. The Fair Repair Bill would require original equipment manufacturers, also known as OEMs, to make tools, parts, and documentation to diagnose, maintain, and repair digital electronic equipment available to independent repair providers and owners. The bill covers electronic devices, a wide range of things from like your cell phone to laptops to household appliances to even wheelchairs, while exempting automobiles and medical devices. And during its stop in Commerce, we also added an amendment that also exempted off-road vehicles too. That would include things like four-wheelers, snowmobiles, farm equipment would also be exempted in the amendment that we took in the Commerce Committee. So the legislation requires that tools, parts, and documentation be offered on fair and reasonable terms. The bill does not require OEMs to release trade secrets, information to independent repair providers or owners, and would only apply to what is necessary to make repairs, not modifications. A violation of the Fair Repair Act would be an unlawful practice enforceable by the Attorney General, and as Council noted, that is where we go to subdivision 4 of the bill. The enforcement by the Attorney General is under Chapter 8 and is involved with the Consumer Protection section under Chapter 8. So that is the quick bill in a nutshell. I do have a couple of testifiers online.
Thank you, Senator Kupek. Whoever would like to go first, if you could unmute and state your full name and title as you begin your testimony. If you have a,
I unmuted, but maybe Catherine should go first.
I'm happy to go first.
Thank you.
Mr. Chair and members, my name is Catherine Murky. I'm an Assistant Attorney General in the Consumer Wage and Antitrust Division. Thank you for the opportunity to testify today in support of the Digital Fair Repair Act. I'm testifying in support of the legislation on behalf of Attorney General Keith Ellison. and focusing on the Attorney General Office's enforcement of this legislation. This legislation addresses a significant problem because some manufacturers restrict access to repair manuals or parts or tools and thereby limit repair options. The legislation has multiple benefits, including increasing consumer choice and competition and less waste. The Attorney General's Office would enforce this legislation if it is passed the same way the Attorney General's Office enforces other consumer protection and antitrust laws. We would enforce this legislation with the authority and the tools under Minnesota Statutes 831. First, the Attorney General's Office would conduct outreach about the new law. We would help spread the word about manufacturer obligations. Education helps prevent violations of law in the first place. Second, if and when the AGO gets complaints, the Attorney General's Office would investigate. Our focus is usually patterns and systemic practices, not isolated incidents. And when we investigate, we evaluate whether the facts violate the law. If we determine there is noncompliance with law, step 3, we can often provide an opportunity to correct the noncompliance. For example, we might contact a manufacturer to address the problem, which can allow for quick action. Fourth, the Attorney General's Office can file a lawsuit in court as a last resort if needed. In doing so, the Attorney General's Office can seek a number of equitable remedies that the court would determine. Those include injunctive relief, restitution and disgorgement, civil penalties, and the Attorney General's cost for the lawsuit. Restitution would go to harmed consumers, the victims. Civil penalties would go to the Minnesota General Fund. Thank you again for considering this legislation and hearing my testimony. I'm happy to answer any questions about enforcement by the Attorney General's Office.
Thank you for your testimony. Next, we'll go to Gay Gordon Bryn. I'm looking over the computer to try to get your name correctly, but if you can state your full name and title as you begin your testimony.
Absolutely, no problem. Gay Gordon Byrne, GORDON-BYRNE. I'm the Executive Director of the Digital Right to Repair Coalition, and I thought I would provide some history as well as to why there's AG enforcement in this bill. Back in 2010, when we were starting to face difficulties with monopolization of repair of large computers, one of the first things we did is we reached out to all 50 states' attorneys general saying, we have a problem here, it looks like a monopoly, please help us. And we did get a couple of AGs to respond, but basically that we didn't get very far. We also went to the US Department of Justice, met with them. They said you really need a legislative solution. And then we wound up being able to copy the first automotive right to repair law that was passed in Massachusetts in 2012. And they had AG enforcement. So we said, hey, if it's good enough for General Motors and Ford, we're going to copy that, and it's probably a pretty good template. And 10 years later, it has turned out to be a very good template. The AG has not been called upon to enforce the law because there haven't been non-compliant manufacturers. So it has proven to be a serious deterrent to monopolization, and it's the reason that we're able to take our cars to the dealership, we can work on them ourselves, or we can use the local mechanic. And this bill really is the same. It just applies to a different suite of equipment. So we carried the AG enforcement into our bill. We considered private right of action, but private right of action is really problematic for consumers because they don't have the kind of skills and ability to, say, sue a big company and be able to pursue that. It's really hard. They need a bigger stick. And our members already have that opportunity of litigation because most of these manufacturers are, in fact, very, very unfair and deceptive, and they meet almost every definition of an unfair and deceptive trade practice. So there is private right of action now. It's not being used because it's impractical. So we did feel that AG enforcement would be appropriate. I don't know what else you would like to say, but the legal background of the bills is we took very close notice of general business law and unfair and deceptive acts and practices. We took very close notice of ownership law, who owns it, where are the responsibilities, who's liable, if somebody gets hurt. And it turns out that it's always the owner, not the former owner and not the manufacturer and definitely not the distributor. So I think we're very solidly founded in law. And I think the Federal Trade Commission, which did a 2-year study on exactly this issue, said, yeah, this is very well founded in law. Consumers are being harmed by not being able to repair their equipment, and there's really no good reasons that they can't. So I will turn it over to the others.
Thank you for your testimony. Next, we'll go to Nathan Proctor. State your full name and title as you begin.
Yes, thank you so much. My name is Nathan Proctor. I am the Senior Right to Repair Campaign Director for PIRG, Public Interest Research Groups, and the Public Interest Network, which includes Environment Minnesota, here in support. We're a network of state advocacy organizations with a nearly 50-year history in standing up for consumers and the environment, and we strongly believe that right to repair advances those goals. So first, I wanted to say that enforcement by the Attorney General is how right to repair is being handled in the multiple states that have these protections in place, such as Massachusetts, New York, and Colorado. We think it's appropriate here in Minnesota. We definitely support that aspect of the legislation. I did want to add that we've had many productive stakeholder conversations here in Minnesota with the other groups, the manufacturers and their associations, and we are in agreement about how enforcement would work. And then just really quickly, in terms of the arguments against this bill, like the same parties that made those arguments also made them to the FTC for 2 years, don't feel the need to replicate that process. The FTC went through the evidence and found that there really wasn't much to support some of these claims. But there was evidence of consumer environmental harm. And so I think we're in a really carefully vetted status here now through all the work that we've done, all the conversations that we've had. And this is a very important issue, which is not going away. And we really appreciate the chance to keep moving forward. Thank you.
Thank you for your testimony. Next, we'll hear from Aaron Kyle Przanowski. Please correct me, state your full name and title for the record as you begin.
Sure. Thanks to the chair and to the members of the committee. My name is Aaron Przanowski. I'm a law professor at the University of Michigan, where I teach and write primarily about intellectual property law. And I'd like to take a minute or two and explain why this bill is consistent with federal IP law. All forms of intellectual property are subject to the principle of exhaustion or the first sale doctrine. And the basic idea there is that once you sell a patented or copyrighted product, the owner of that product is free to use it, to resell it, or to repair it as they see fit. In patent law, that rule goes all the way back to the 1850s, when the Supreme Court decided a case and said that owning a patented device carries with it the right to use that machine for as long as it's capable of use. And that's a rule that the Supreme Court has re-embraced as recently as 2017. On the copyright side, we've got similar law going back to 1901, when the Seventh Circuit held that the right of ownership in a book carries with it and includes the right to maintain that book as nearly as possible to its original condition. So our starting point, I think, has to be that the right to repair is an inherent feature of ownership and one that's fully consistent with federal IP law. And it's not just the courts that have said that. Both Congress and the Copyright Office have endorsed the legality of repair under copyright law. And so I think state-level repair bills are consistent with that long-standing federal policy. I would point out the bill we're considering here today is fairly modest. It does not permit third parties to make or distribute copies of copyrighted software or patented parts. It doesn't force manufacturers to make and sell parts or software that they're not already producing and not already making available to their own repair providers and folks within their authorized repair networks. It simply tells manufacturers that they have to deal with the independent shops and consumers on the same or similar terms under which they're already distributing those parts and tools to other parties. So thank you for your time, and of course, I'd be happy to answer any questions you might have.
Thank you for your testimony. I believe we have one more testifier in person. Tony Quilas. And state your full name and title for the record as you begin.
Madam Chair, members of the committee, my name is Tony Quillis, and I'm representing the Consumer Technology Association. It's a trade association with just under 1,400 members that represent manufacturers and retailers in the technology industry. Madam Chair and members, in regards to Senate File 1598, the preferred approach would be a national law or a national memorandum of understanding, but short of that goal, we'd like to prevent a patchwork of rules and regulations that would be confusing to all stakeholders involved. Up to date, the only one other state, New York, has passed a law regarding right to repair. And as Mr. Proctor pointed out, there have been some very constructive conversations among stakeholders to be able to provide some clarity and consistency with elements of the New York law and the proposed law to prevent a patchwork that I had just previously mentioned. Unfortunately, we haven't reached a mutual agreement yet, but there's some outstanding issues that we're working our way through in regards to definitions and some implementation issues. And so we're going to keep having conversations with Senator Kupek and the advocates, and I'm hoping that we're going to be able to reach agreement here as we move forward. So I just wanted to be able to get that on the record, Madam Chair, that we're opposed to it right now as written, but there are, as I said, some good constructive conversations, and look forward to working with the advocates and Senator Kupek as this moves its way through the legislative process.
Thank you for your testimony. That conducts our list of testifiers. So members, questions, comments? Senator Kroon.
Thank you, Madam Chair. I would like to echo the fact that I think this should be federal legislation. That seems just abundantly obvious to me, that the idea that all 50 states are going to embark on their own law here seems completely unworkable. Having said that, I see certain benefits. I'm not totally opposed to some of the things that are in here and the benefits to consumers. So that leaves me in a bit of a quandary. But my hope is that all of the people that testified today take this to the federal level and get something done there. I don't know how this is going to be workable otherwise.
Okay, seeing no further comments, Senator Kupek.
Sure. Thank you, Madam Chair, and Senator Kroon. I think the one thought is this: there is also legislation pending in some other states. Colorado also has a similar bill, and I think maybe that if there are enough similar bills, that it will, if enough states do it, there'll be some adoption. But probably it would be nice if our federal government did a few things too. But
Senator Kroon.
Thank you. Or maybe you could have some sort of uniform Fair Trade Law Commission or something like that, and everybody, all the states can adopt the same thing. But something's got to happen here where there's some uniformity.
Senator Carlson.
Thank you, Madam Chair. And Senator Kupek, I'm surprised. I thought that one of the major motivators behind this was farm equipment, and I see now you have it excluded from being covered. And in fact, I did look at the long list of things that are not within this, and it does surprise me. I know you didn't include cell phones, but I'm very surprised. I've been on both sides of this issue because I do like to do a lot of repair myself, and I like to, but also my family was in the farm equipment business, and, you know, anybody that makes any kind of equipment like that does want to make sure that the equipment gets repaired correctly, and also, you know, that's sometimes where their profit comes from too. So I guess, and I just looked it up, and it said that 20 states have already filed the right to repair legislation. So it's coming, and I think the changes you made on it push me over the top. So I'm going to support it.
Senator Kupek?
Madam Chair, Senator Carlson, yes. And I think some of that is because this legislation is coming up in states, particularly around some of the farm equipment. We have had John Deere and I believe Case just announced they have memorandums of understanding that in many ways are very similar to the legislation we've proposed. Ideally, I think I would like to see that put down in the code somewhere. But I think it is because of legislation like this that they moved to that understanding. So with that, we did make some exceptions. And it does also, some of that with farm implement dealers, there were some other concerns raised about that too. So that was why we made that exception.
Thank you, Madam Chair.
Final comments, Senator Kupek?
Sure, I would like to also, Mr. Quillis was up, and there are some other amendments we will likely also be taking to this bill. Some of them were just not germane to this committee, but certainly I think as this goes forward, we continue to work here with the other stakeholder groups to really get this in a form that is a little bit probably more uniform with some of the other states that are also passing these.
Thank you. With that, Senator Carlson moves that Senate File 1598 be recommended to pass and sent to the Senate floor. All those in favor say aye. Oh.
Yeah, sure.
Okay.
I wasn't sure if it was going back to Commerce or to the Senate floor.
Yes, okay. Senator Cooper, we just confirmed.
Okay.
So all those in favor say aye. Aye. Opposed? Okay, motion's adopted.
Thank you, Madam Chair. Thank you, committee, also for the pizza offer, but I have a better offer. I have dinner with my wife.
Senator Kupek, if you want to invite her, we can all have dinner with your wife.
That's not so romantic.
Senator Klein has been waiting very patiently, observing the inner workings and the outer workings of the Senate Judiciary Committee. We're going to take up Senate File 1949, Lawful Sports Betting. Senator Klein, we're going to have the materials distributed to the committee. Looks like maybe it's already been done. This is not your first committee, Senator Klein, so why don't you go ahead. Actually, why don't we ask counsel to identify for us what provisions we should be paying particular attention to, and then we'll have the chief author describe the bill to us.
Mr. Chair and members, I'll mention the criminal provisions, and then Ms. Primo can mention the civil provisions. I think this is somewhat similar to the cannabis bill in the sense that the general issue of whether to make this legal or not, sports gambling, is somewhat in our jurisdiction as a big picture issue. And then specifically Article 3 on page 31 is all criminal provisions. And then with that, I'll ask Ms. Primo to fill in the rest.
Ms. Primo.
Mr. Chair and members, the additional provisions are related to data practices. The first is Section 16 on page 20, which deals with the privacy of the exclusion list, and Section 23, which begins on page 28, which classifies certain data as private or non-public.
Thank you, Ms. Primo. Senator Klein, tell us a little bit about your bill.
Thank you so much, Mr. Chair and Committee, and I know you've had a long day. I will speak to the bill as a large, big picture item, since it is true that the very question of whether to legalize something that is currently illegal is certainly in the domain and wisdom of this committee. So I assumed the chief authorship of this bill this year for two reasons. First of all, Minnesotans in large part are already accessing and demanding sports wagering as a legitimate recreational activity, and it is the job of this legislature to make sure that it can be done in a safe, trustworthy way, and that it has guardrails for problem wagering and underage use. The larger reason that I took this bill on this year was as a historical justice issue. Tribal gaming in the state of Minnesota has restored financial independence, power, and basic services to our 11 Native American tribes, which were devastated over the last 3 centuries. Protecting that exclusive right to gaming as it expands into new areas is essential to continuing that work. This bill will be developed as it goes forward to state government after your committee, but one principle which is not open for amendment or discussion is tribal exclusivity over these licenses. This bill does enjoy the support of our Major League Sports franchises, for which I am grateful. As you have heard in previous testimony in prior committees, it does not currently enjoy the support of the tracks in Minnesota. I do acknowledge as chief author that those tracks are a Minnesota destination experience, not unlike a trip to the State Fair or the North Shore, and I'm committed to working with the tracks as it moves into state government to find ways to satisfy their concerns. Specific to the areas of jurisdiction of this committee, Mr. Chair, Article 3, which was pointed out by counsel, are the criminal provisions related to sports gambling. Subdivision 2 deals with selling data. Subdivision 3 deals with underage wagering. Subdivision 4 is the section related to placing unauthorized wagers with criminal penalties that range from misdemeanor to felony based on the degree of offense. Subdivision 5 deals with accepting unauthorized wagers. Again, penalties ranging from misdemeanor to felony based on severity of offense. Subdivision 6 provides that these can be aggregated so that cumulative offenses are aggregated. Subdivision 7 deals with false or fake IDs. Skipping to Section 8, which deals with bookmaking or people who make acceptance of wagers when they are not licensed. And Section 9, which deals with fraud and bribery by participants in an athletic event who may throw an event for the purposes of wagering. And then the data provisions and privacy provisions that Ms. Primo identified are in the sections that she identified. I will say as a collective, these provisions around criminality and civil penalties are consistent and aligned with those instituted in other states that have legalized sports wagering. Thank you, Mr. Chair.
Thank you, Senator Klein. Do we have any testifiers? I don't see any on my list here, but I'll ask.
There are no testifiers.
All right. So, members, we do have an A4 amendment before us. I've consulted with counsel, and it appears that the first half of the amendment is more properly within the jurisdiction of state and local government. They have not heard the bill yet. It was originally referred there, and then it was withdrawn and re-referred to Commerce and then Health and Human Services, where it came here. So it appears that the first half of the amendment down to line, including line 110, are more properly in state and local government's jurisdiction. I'd prefer to that we leave that to their determination whether to add it to the bill, so that when the amendment is offered, it would be to only for lines 1.11 to 1.17. Senator Klein, can you tell us what the amendment does, or counsel, either way?
I can, Mr. Chair.
Just from line 11 to the end. Senator Klein.
From line 11 on, absolutely. And these were changes that were suggested both by your council and also by the Department of Public Safety.
Senator Klein, if you wish, council is prepared also to do that. If
Why
you,
don't we go ahead with that?
Mr. Backus.
Mr. Chair, just beginning on line 1.11 then.
No. Was it, oh, sorry. My mistake. 1.11, yes.
Okay.
I need dinner.
Yeah, the changes on line 111 to 112, there's currently a crime for sharing information related to gambling, but the bill authorizes sharing for certain information with the sports governing body. So this puts an exception there so that information, that sharing which is authorized in the bill, isn't inadvertently made criminal. Then line 113 to 114, and then the rest of it was suggested by the Department of Public Safety. 113 to 114 basically narrows the crime for people associated with the Department of Public Safety who can't, under the bill, they can't essentially engage in sports wagering. It would be a crime. This limits that, so it would only be members of the Division of Alcohol and Gambling Enforcement, because they're the ones actually working on the sports wagering and all that. So it seemed to make sense to limit it, so it didn't include the entire Department of Public Safety. And then 115 to 117, provides an exception for the gambling crime so that a peace officer with the Division of Alcohol and Gambling can place a wager as part of a criminal or a regulatory investigation without being convicted of a crime themselves.
Is there any discussion with regard to the A4 amendment, lines 1.11 to 1.17? Senator Oumou Verbeten moves adoption of the A4 amendment, lines 111 to 117. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment is adopted. To the bill, is there any discussion, questions from members of the committee relating to the bill? I'm going to give a moment for members to be able to read through the provisions that are identified in our jurisdiction so we can digest them before making decisions here. Ms. Primo? I have a question relating to section 23 on page 28. It creates a data classification. Who is holding this data? So to whom does this classification apply? Do you know? Or Senator Klein, if you know?
Mr. Chair, I believe that
Senator
data
Klein.
would be collected by the platforms, the entities such as DraftKings, et cetera, who sort of are the platforms for these wagering operations.
The reason I'm raising the question, Senator, is Chapter 13 for almost its entirety applies to government data, not data maintained by private entities. So maybe I can get some clarification from Ms. Primo on that.
Mr. Chair and members, I think it would be the Department of Public Safety just because of where this is being placed in statute. And I'm not as intimately familiar with the structure of the bill if there's a specific division being created within the department, but it would be the Department of Public Safety. That it's the government entity that holds the data.
Senator Klein, now when you get that pointed question on the Senate floor, you'll have an answer at hand. Because we know Senator Limmer is going to have fly-specced the entire bill by then and will be ready for you on the Senate floor. All right, do members of the committee have any further questions or discussion relating to Senate File 1949? Senator Kroon.
Thank you, Mr. Chair. Regarding the overall, not a specific section, but the overall question of whether the state should make this legal. For me, I don't have any particular issue with legalizing sports gambling, but I do have running aces in my district. And this is obviously a very big concern to them, and I'm glad to hear that you are continuing negotiations with them to see that they whatever impact is minimized by this bill, and that would be important to me and to my district. It's a huge amenity for our district. It employs a great number of people, and it attracts a large number of people from across the North Metro and beyond. So, if you have any. Did you say that you're actively in talks with the tracks, and if so, and the horse breeders too? Are they included in this? If you could comment on that,
Mr. Chair. Mr. Chair, Senator Kroon, yes, absolutely. Not only I, but the tribes themselves more intimately are involved in discussions with the tracks to see if there can be an accommodation that would satisfy both parties. I think that is important work. I also think it is a political necessity in this body that there be some arrangement arrived at. I have met with the CEO of Running Aces and heard his concerns, and we have spoken on a few occasions. And I support your concern that this is a significant venture in your district. So.
Is there any further discussion? Senator Klein, I'm told this goes to taxes next. Is that your understanding, or am I looking at the wrong sheet here?
Mr. Chair, I think it should go correctly to state government, and thereafter it will go to taxes and finance.
One note says taxes, but we've already talked about state government, not having heard it yet. So if that's your understanding, we'll send it to state and local government. From here, Senator Oumou Verbeten. Move it?
Yes,
Okay,
thank you,
Brenda.
Mr. Chair. I'll move that Senate File 1949 as amended be recommended to pass and re-referred to the Committee on State and Local Government and Veterans.
Senator Oumou Verbeten moves that Senate File 1949 as amended be recommended to pass and be re-referred to the Senate Committee on State and Local Government and Veterans. Seeing no further discussion, all those in favor say aye. Aye. Opposed? The motion prevails. Senator Klein, thank you for your patience today.
Thank you, Chair and Committee.
I see Senator Wickland has made an appearance. Senator Wickland, welcome. Come on forward. Members, we are going to take up Senate File 2400.
Thank you, Mr. Chair.
We're going to have the packets distributed to the committee members, so give us just a moment, Senator Wickland.
Sure. I don't have their packet. I don't have what they have, so you're going to have to talk about it.
The amendment?
No, I have an amendment. I don't have the last version.
Members, I think everyone's received their packet. This is the Committee of Original Jurisdiction, looks like on this bill, and
Mr. Chair,
which makes me wonder a little bit why, but go ahead, Senator Wickland.
this is a clone bill. We had heard it, the bill was heard in HHS. We've had a hearing in Education Finance, and we're having a hearing in your committee, so.
So we're multi-tracking this to make sure it makes
That's
deadlines,
correct.
it sounds like.
Yes,
All
exactly.
right.
So,
All right, members, we do have, well, I'm not sure if this constitutes an author's amendment kind of situation or not. Council is trying to figure that out, too.
that's why I wanted
the
to,
amendment that
Mr.
is.
Chair, describe that, so you had the full scenario.
Let's just, why don't you tell us basically what the bill does, and then we'll have Ms. Primo tell us what specifically has brought this bill to our committee and focus your attention on that as well.
Thank you,
Senator
Mr.
Wickland.
Chair. Yes, Senate File 2400 is a bill that would establish a new agency, the Department of Children, Youth, and Families. We know that we're all striving to create a better state in Minnesota for families. Families deserve a safe and healthy place for their young children to learn and grow. Currently, Minnesota has over 9 different early childhood education programs that are managed by 3 different state agencies, which makes it difficult for families and child care providers to navigate. This is why we need a new agency that reimagines the structure and places children, youth, and families at the forefront. This new department will impact early childhood programs. It will consolidate early childhood programs to streamline the system for both child care providers and families by improving coordination, aligning administration, and using a common application for families to apply for programs and services. It will invest in our youth by bringing together programs for children and youth focused on youth needs across the state when outside the classroom and in their communities. And it will also lift up a safety net of family well-being programs, including economic and food assistance, a network of community resource centers and services for adults caring for children. This new department will ensure that we have accountability at the cabinet level to serve all our children, low-income children, and address racial disparities and develop a stable workforce. It will also ensure coordination of resources to create a seamless delivery system of early care and education. It will contribute to greater communication to the public, ensuring high-quality programs. and it will bring greater visibility of these programs and the economic importance of investing in them. Mr. Chair, I do have testifier who can go into more detail if you'd like about the bill and the transition process. Mr.
Ms.
Chair, I don't
Bailey?
want to add more detail than you're looking for, but I will continue to provide more detail if you're interested.
Thank you. Why don't we have counsel identify for us specifically what provisions we are looking at within our jurisdiction, and then we will hear from Ms. Bailey. Mr. Backus.
Mr. Chair and members, I think Ms. Primo might have something as well, but I would refer you to on page 14, beginning on line 17. The bill transfers powers and duties of certain existing agencies and moves it to this new department. Relevant to this committee would be the transfer of the Juvenile Justice Program on line 14.21 and then the YIP program on 14.22.
Ms. Primo.
Mr. Chair and members, and the other reason, the other piece is related to data practices. The language begins on page 7 at subdivision 3 and continues on to the next page. And I believe there is an amendment in the packet which covers data practices as well.
Ms. Bailey, why don't you go ahead and provide us with your testimony, if you could focus on the provisions within our jurisdiction. Go ahead.
Chair Latz and members of the committee, my name is Erin Bailey, and I'm the Executive Director of Minnesota's Children's Cabinet. The Children's Cabinet is housed at Minnesota Management and Budget and refers to the convening of states commissioners around children and youth. Understanding the robust agenda and committee's jurisdiction on this bill, I'll provide a very brief high-level overview of the proposal to create a new cabinet-level agency for Department Children, Youth, and Families. I'm joined here by agency colleagues who are excited about the moment we're in for transformation for young people. The proposal before you today is based on feedback over many years from families, local service providers, and those who work with them who have been asking for state leadership, vision, and coordination, engagement, and culturally responsive programs that meet the needs of their children through their development. With learnings from youth and families, providers and leaders, governance reports, cross-agency work, OLA reports, and other states, in our renewed Children's Cabinet, we have a proposal before the legislature to re-examine our governance structure and to create an agency, as Senator Wickland said, centered on children, similar to the governance structure in more than half our states. I think I'll skip kind of the testimony really related to other components and focus, as you said, on this, the jurisdiction before the committee. We are proposing to move the Office of Youth Justice to the new agency. My colleagues from DPS can speak specifically to this, but the need and goal is prevention and centering on community response, putting youth first in our state government. We hear from inside and outside state government the importance of distancing our youth engagement and support strategies from deep end systems like public safety and corrections. The bill obtains the authority and resources to support this creation and alignment through a 2-year process that would fund both a transition process, the appointment of a new commissioner to make sure that we are proving continuity of services and moving towards this mission. As Senator Wickland shared, the data sharing language updates we've worked on with advocates and legislators. The language as amended includes permissive data sharing to support the transition of programs to the new agency while continuing to protect data. This language enables an efficient, time-limited approach to sharing only the data necessary to coordinate the department activities and services proposed in the bill transfer. We must act boldly in this moment, learning from years of engagement
research in other states before our state depends on the success of our children, youth, and families. We have a plan to take the time, continuing to listen and engage with agency staff, experts, our tribal and county partners, our families, and all of you. We see many opportunities for youth and those who serve them, including moving upstream, creating a governance structure that more explicitly enables a focus on prevention and supportive services that amplify youth voice and build their skills and potential. I'm happy, Chair Latz, if comfortable, to turn it over to my colleagues at the Department of Public Safety to speak more about the specific program related to the committee's jurisdiction. Thank you.
Thank you, Ms. Bailey. Come on forward, identify yourself for the record, and go ahead and proceed with your testimony.
Thanks, committee. I will note that Aaron and I did not coordinate, but I'm not mad about it. Good evening, everyone. I'm Katie Knudsen. I'm the Chief of Staff for the Department of Public Safety, and it's good to be with you all today. The Department of Public Safety supports the work of the Juvenile Justice Advisory Committee to maintain compliance with federal protections designed to keep kids in the juvenile justice system safe and to reduce ethnic and racial disparities in the juvenile justice system through the work of the DPS Youth Justice Office. Federal guidelines state that every U.S. state and territory must have a body that advises the governor, legislature, and stakeholders about juvenile justice issues. In Minnesota, that body is JJAC. This advisory body must oversee Minnesota's compliance with federal law protecting youth in the juvenile justice system and to eliminate racial and ethnic disparities. This is big work. It's important work. Having formerly worked at I'm sorry, that's the commissioner's talking point. He's not here this evening. Historically, DPS has had just one juvenile justice specialist to provide all of the support and logistics for JJAC. In 2021, DPS requested and the legislature invested in additional resources to help launch Minnesota's Youth Justice Office. That office, we are proud to announce, now employs a director, an ethnic and racial disparities coordinator, and a compliance coordinator that supports the work of the 21-member JJAC board and its 6 subcommittees. With this additional investment, key resources, energy, and time can be given to compliance measures, reducing ethnic and racial disparities, and to focus on youth mental health, outreach, and education. Over the past 4 years, the Department of Public Safety has seen the benefits of the cross-collaboration and connections forged by the Children's Cabinet and leveraging expertise and resources across agencies to better support youth throughout Minnesota. The proposed Department of Children, Youth, and Families institutionalizes that approach by placing the work of the Juvenile Justice Advisory Committee and the Youth Justice Office, along with the YIPA grant programs, alongside similar state agency efforts. This proposed approach ensures that children and families receive timely access to an abundance of coordinated resources and supports, reducing the likelihood that a child will ever interact with the juvenile justice system. Finally, this new department could assist Minnesota's youth-serving organizations in accessing information and applying for grant funding, resulting in an increased availability of and access to community-based services aimed at enrichment, therapy, recreation, education, engagement, rehabilitation, and other prevention and intervention approaches. No matter what, DPS is committed to continuing to work towards ensuring that youth and families remain supported in Minnesota and to invest in prevention and intervention alternatives to keep Minnesota youth from ever coming into contact with the juvenile justice system. Thank you, Mr. Chair and members.
And thank you for your testimony. You could stand in for the commission. Do you have any further testifiers, Senator Wicklund?
I don't think, just for, Mr. Chair, I think there's people here who can answer questions if they come up. So.
All right, thank you. Yeah, I don't have anyone else on the list. So we do, members, need to consider the A1 amendment. So it looks to me like the A1 amendment deletes the data practices language on page 7, rewrites it a bit, and inserts it in a different place in the bill. Is that about right? Maybe what we should, I've already read through them both, but maybe we should have Council or Senator Wicklund tell us what the differences are between the language that's being deleted and the language that's being inserted in its place.
You want to go through it, or do you want Council?
It doesn't matter.
Ms. Bailey?
Chair and members of the committee, after hearing feedback on the original data sharing language on the bill, we've been working with legislators in both bodies advocates, and the administration on an amendment to address concerns that were shared. The updated language replaces the introduced language on the data practices with new language. This language is time-limited for 4 years and authorizes data sharing only between the agencies directly involved in the program transfers. It limits data sharing to the programs proposed to transfer and for the purposes necessary to coordinate activities and services. The language also clarifies that the classification of data will be retained and existing limitations on legal requirements, including consent requirements, continue to apply. Thank you, Mr. Chair.
Ms. Bailey, what is the purpose of expiring this section in 2027?
Mr. Chair, members of the committee, I'll take the first part and then may defer to the General Counsel of the Department of Administration as well. The section really allows for the transfer of activities as we've proposed sort of a process that would allow a 2-year transition to make sure we get it right, that there might be some complexity around the timeline of when programs might transfer to that new agency. And based on the feedback we heard, really a desire to not have that language be allowed over a long period of time, but really for that purposes of the transfer of activities.
Counsel, do you have something to add? Go ahead and introduce yourself for the record, if you would.
Thank you, Mr. Chair and members. My name is Stacy Christensen. I'm a Deputy Commissioner and General Counsel at the Department of Administration and have been assisting with the data practices provisions in this bill. I believe Ms. Bailey explained it accurately. There are current provisions in law in Chapter 15 related to the transfer of existing agencies. Because this particular situation, we're going to have an implementation office, we needed a bit of stopgap measure to make sure that the data appropriately flows from the programs that are being transferred. So that is why the sharing provisions are time limited.
So, Ms. Christensen, is it assumed then that at some point there will be no longer be a need for data sharing between the previous residents of the data and the new residents of the data? Ms. Christensen.
Mr. Chair, that's an excellent question. It was something that came up in speaking with advocates because the real need is during that implementation period. They wanted to make sure that the data sharing was a bit more limited to for that particular time. There potentially is some broader data sharing that's needed in the future, but they wanted to see kind of where this department landed in the meantime before that was put into permanent law.
One of the issues that we have faced in this committee are bills that come along or provisions that come along that say this department, this agency, this holder of data wants to be able to respond to some circumstance, but they can't because they can't get the data from somewhere else that they need to have it from in order to be effective and respond. So is that the kind of thing you might be anticipating possibly down the road, but you don't know yet, and you're going to wait and see, and you'll come back at some point and say we do or we don't? I guess if you do, you'll come back.
Mr. Chair.
Ms. Christensen.
I believe that's accurate.
Okay. Yeah, I see the difference in the language that the consent requirements among other things are specifically carried over, which is different than the original language in the bill. Or at least it's clarified to make sure it's covered. Senator Limmer.
Thank you, Mr. Chair. Senator Wickland, has any of our privacy citizens out there that like to track this stuff, have they given you any indication that this new language is, or do they have concerns or a blessing on any of it?
Mr. Chair.
Senator Wickland.
Senator Limmer, we have been speaking with one of these citizens and had worked quite over the past couple of weeks with him, and I think we've gotten to the point where he's, I think, I don't know, you probably had the last contact with him, but I think we've gotten from where he was not comfortable to where he is more comfortable, and if there is anything else, I'm sure he'll let us
This
know.
mysterious
Senator Limmer.
citizen that we're talking
Yeah.
about wouldn't be Mr. Newmeister, would it? And then the organization, Minkoji, have they been in contact with you?
Ms. Bailey.
Yeah, Mr. Chair and Senator Limmer, we shared the language before our testimony in the House with Minkoji, and they were comfortable and did not have concerns.
All right,
Thank you.
thank you.
So I have a question. Senator Limmer might be interested in this question as well. On page 14, this bill proposes to move from the Department of Public Safety the programs on juvenile justice and youth intervention programs, YIPA, as it's commonly known. Those programs are near and dear to this committee's jurisdiction, and a lot of us here care a lot about them. So I don't know that it necessarily says anything about what future Senate committees might have jurisdiction over these programs or the funding for them. But I wanted to note that you're bringing a bill to us that's going to create some heartache if we pass it out of here, because we don't I don't want to lose these programs that I have fought for and on behalf of over, years of service. Doesn't mean I won't be able to, but I've had more direct ability to do so serving on this committee. Am I understanding correctly what it is that's being sought here? These programs be removed from DPS and sent to the new agency? Senator Wickland.
Mr. Chair, yes, I think that as Ms. Knutson talked about, I think there's a desire to consolidate these programs into one agency where kind of the whole child, family can be considered and services coordinated. And I think Ms. Knutson can probably speak to that segment of the programming that would move over. But I think the desire is that we have a more holistic approach to children and families, and that includes some of the activities in these programs. And then also to have an approach where we're looking at prevention and upstream factors and the challenges that families face in just accessing all the services they need. So this is meant to help kind of streamline that and be more coordinated. But I'm not nearly as knowledgeable in those particular public safety programs, so I'd let you add more to that.
Thank you, Mr. Chair. I do think that Senator Wickland and you have identified it correctly. We are proposing to move those YIPA grants over for those reasons. Prevention and intervention is at the heart of the new agency, and we do think that those youth grants make sense to go there. But of course, we look forward to feedback from you on that proposal, and if that causes so much heartache that it breaks your heart, we would, of course, consider that choice.
Thank you, but my interest is in the programs being successful and well-funded.
Us too.
And it may well be that you will be able to get more funding in these programs than we can within the Judiciary and Public Safety budget. They'll be more front and center in terms of the mission of the new agency.
Right.
And so they might be better off there than here. Any discussion or comments from members of the committee relating? Did we adopt the A1 amendment yet? I suppose we should do that at some point.
Mr. Chair, I'll move the A1 amendment.
Not seeing any further discussion on that, Senator Oumou Verbeten moves adoption of the A1 amendment. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment is adopted. To the bill as amended, any further discussion? Senator Wickland, what are we supposed to do with this bill that is multi-tracked in a variety of committees? We've added the amendment. I suppose we could lay it over, and then wherever the bill is going to be assembled for its final journey toward the floor, can incorporate our work in that. Is that what you'd prefer us to do?
Mr. Chair, that seems like that would make sense. I would be including it in an HHS, omnibus, so I will be bringing in, this amendment, but there's another amendment that was added in finance, so we'll have to incorporate that as well, so.
Well, maybe if it's going to be in your committee's omnibus bill, maybe we should just send this back to your committee.
That would be fine.
And then you'll have formal jurisdiction over it with our changes.
That would be fine, yeah, thank you.
Any further discussion on this bill? I'm not seeing any. Senator Oumou Verbeten moves that Senate File 2400 as amended be recommended to pass and be re-referred to the Senate Committee on Health and Human Services. All those in favor say aye. Aye. Opposed? The motion prevails.
Great.
Thank you, Senator
Thank you.
Whitlam and testifiers.
Thank you very much. I'm really happy to get in before the pizza hour.
Well, I just want to check with staff and see when the pizza delivery is imminent. Okay, so we're anticipating between 7:20 and 7:30, so we're just going to keep on going. You got to talk to Tony and tell him that we are expecting pizza. We got a bunch of hungry members here.
I had Lunzer call in the order.
Oh, well. Like too many restaurants, Tony is running short staffed, which is why he is only takeout now and not in service. Okay, so members, we're going to take a brief recess to the call of the chair as we're determining if we have testifiers for the next potential bills.